27, you want to withdraw. And the request of the, allowed, The Relevant counsel for petition submitted the request of the petition has been accepted by the authorities and therefore we have no further grievance. He seeks permission to withdraw the permitted dismissal. Yes.
Page number 4, item number 45 to 54. Page number 5, item number 55 to 68. Page number 6, item number 69 to 73.
Item number. Used.
Page number 7, item number 74 to 88. Page number 8, item number 89 to 100. Page number 9, item number 101 to 117.
Yeah, probably. Yeah, find a stay vacant also.
I only explain that.
Has to be allowed. And where is the other side? No to 30, whenever it reaches. No to 30 is now. It is accepted. Whenever it reaches, it reaches.
Page number 10, item number 118 to 130.
Nothing makes mistake done by outside. It is as much correction in 3 months.
So you make a mistake and then the court has to do the corrections. Huh?
Repair and activate. Small mistake in interim break.
And that has been done. 114.
I have just filed the petition on kept it on file vacancy petition because we taken up the time of
It will come up in the regular court.
it was instead of policy we did not reach the launch. Then
No, now everything will reach.
then
And reach it. Huh.
Payment is likely has not been paid for taken from free. Then you got it very fast. Why we don't have?
On 21st on the actual one.
Subject Lordship kind permission, my lord. 2021 matter, my lord, matter pertains to punishment without inquiry, my lord. Your Lordship, any convenient date, my lord. Oblige.
Pension and gratuity. 2021.
For posting, you please give it to them. They'll come in the list. And as and when it reaches, we'll take up. No mentioning that it should be taken up at 2:30 hours. Unless until it is very urgent, no mentioning. Yes. What is the issue? Salary issues. No, not the city. 22nd, the adjournment.
May I make it?
Yes,
That item number 322 and 323. This is a matter of writ of co-warrant, my lord. I filed an amendment of prayer petition.
okay.
Taken up on Tuesday, my lord.
Only the amendment petition is to be taken up.
Yes, Tuesday, my lord.
We'll say the adjournment.
May it please your lordship. That is IA number IA2 of 23, Malad. This is contempt coming up 1711, Malad. Before contempt, Malad, like find it any date, Malad.
Post along with the contempt. Say we can. Along with it. Yes.
May it please your lordship.
Yes, yes,
Item number 338, my lord.
yes.
The petitioner is working in Tribal Welfare Department as attender in Mannor, Mahabubnagar district, my lord. It was merged into MADA during his service. His salary was paid under 010 and 011, my lord.
Yes.
Out of 8 employees, 7 employees are getting salaries, my lord. Only our petitioner is ignoring.
He is not getting the salary at all.
Notice, we have filed the entire the
You are
material.
getting the salary. No, are you getting the salary and not, no salary at all? You are getting the salary under a different head. You want
Not
the-
getting the salary, my lord. We have already filed all the material papers which is supporting our contention, and kindly post this matter in the top of the list, my lord.
Post this matter on the 28.
Not obliged.
Item number 185, Your Lordship.
Yes,
Item number 185, Your Lordship. So we amended the prayer, Your Lordship, including the impugned order.
okay.
And the person is not getting salary more than 6 months. And kindly list on today afternoon or tomorrow or Tuesday, Your Lordship, as per your convenience.
When did you file the amendment petition?
Yesterday, madam. Yesterday, Your Lordship.
So you're not getting the salary for 6 months and you amended yesterday.
Last week only we called, you ordered to amend the prayer.
22nd.
Because of impugned order is missing in the prayer.
It will be
We filed
listed on 22nd. Yes.
Much obliged.
Your Lord, item number 361, Your Lordship.
Yes.
Your Lordship directed me to mention after Dasara holidays. Hence, I mentioned on 2nd November 2023. Item number was 90, Your Lordship. On that day, after 3:45 p.m., transmission disabled, Your Lordship.
Oh, what is
I
the,
have been trying.
oh, what is
She
the
was
issue?
appointed. Issue is a direction petition was ordered to be listed on 6th April
What is the
2023.
issue? What is the
Issue
issue?
is he is working on contract basis in Gram Panchayat. Karobar scale was given to others, but he was ignored, Your Honor.
It will reach. When
That's
it
why I was-
reaches, it will be taken up whenever it
Any day.
reaches. It will be
Your
taken up
Lordship.
whenever it reaches. It's in the list. It will only be going up in the list. Whenever it reaches, it will be taken up. Yes.
Any day you fix it one day, Your Lordship.
It's already there in the list, sir. It will
It
reach.
is already
Whenever it reaches.
361. It may not come, Your Lordship. Any day, tomorrow, day after tomorrow, I'll wish Your Lordship.
No, it will only be going up in the list and whenever it reaches, it will be taken up. No further submissions in this. Yes.
Obliged.
Right. Whenever it reaches, you make them.
Subject to your lord.
No, it's not listed. Sir, children, touch part like.
Subject to list. Item number 36, point sections are written.
Item number 26.
36.
36. Yes,
Plus.
36. Dismiss as evidence. The letter forms to be submitted that the matter has to be interested. Yes.
Item number 161, TSHIGHCOURT.
May I please, Lordship? My Lord, Lordship, may kindly permit to withdraw with liberty to file fresh writ petition, my Lord. Matter pertains to pension, my Lord.
Why are you withdrawing now?
Because he has not made proper parties and not submitted any judgments and there are some, there are several amendments.
Find the letter form, so.
With liberty, my Lord. Obliged.
Milord, this is a matter, Milord, your lordship may have a look. There are two people involved in the same, Milord, same charge memo is issued for two people. After that, inquiry is conducted, Milord, punishment also imposed the same punishment. Then, Milord, what happened for other person, Milord, government has set aside the entire punishment. As far as the petitioner is concerned, Milord, they have dismissed the revision. So
Okay.
I'm seeking to pass orders, Milord, saying that in view of that, Milord, let them consider. Last occasion when it has come, Milord, your lordship has asked me whether I filed any revision. I filed it on 26/10, Milord, revision. Second time revision.
Where is
And they
that?
have to pass orders, that's all, Milord.
No, where is that revision? Have you?
Revision. Revision, Milord, I did not file before your lordship, Milord, because it is, I could not file it, Milord. But I filed it on 26/10, Milord, after it has come before your lordship.
Yes.
Next week, Lord.
Consider the revision, that's it.
That's it, Milord, that's it what I'm asking.
Not failure,
You give a copy and at least you should file a copy before this court.
not given.
You give a copy next week. What is it?
Match up.
Yes.
That's nothing. Okay. Same of money. Since
What is the stage of the, what is the stage of criminal case? Huh? Definitely. What about the disciplinary proceedings? It's only a memo issued now. Submit what? Inquiry officer has been appointed?
Yes.
Where is it? Then, see, what stage should this stay be granted? If there is no inquiry even being conducted, then let it go on. Where is that? Where is the, who is the inquiry officer? When was he appointed? Immediately after issue a charge memo, issues of a charge memo, you immediately write to the post. Huh?
Get instructions.
All right. At the request of the learned special DP performs the instructions in the matter. This next week?
1
Huh?
week.
It's on 20th. Adjourned by.
Wait. Services.
May it please your lordship. The petitioners, because of the date of birth, they lost the opportunity of getting selected, my lords, in the police constable TSHC. My lords, the notification says, my lord, whenever the marks are equal, then age will be taken into consideration, and whoever age is more, they will be considered, and the less age is not considered, my lord. But whereas here, my lord, these two petitioners belong to Kamaredi, where there are 15 vacancies, 15 absentees there in attending the submitting the attestation form itself, my lord. My lords, page number, my lord, 17, my lords. 17, it's,
Considered against the unfilled vacancies.
pardon me?
Want to be considered against the unfilled vacancies.
Yes, unfilled vacancies. My lords, there are 3 phases in attestation form. There are 15 people absent. And after that one, medical will be there. Medical, there are so many people going to be because of eyesight, etc. And after that, antecedent check. Minutes, any pending cases there. So therefore, now it's the beginning stage itself, there are 15 vacancies left. So they are not considering, and their intention is to carry forward to the next notification. When everybody is unemployed, youth is waiting for the jobs. So it's not
Yes. Tuesday. The request of the learned. Get instructions in the matter.
motion is Milan.
Item number 5.
May it please, Lordship. And that's my petition of Lordship's is the employee. Lordship's the responding will initiate the disciplinary proceeding basically. Criminal case matter. Registered the case under 498 Lordships. They say is file the CC and Lordship's the responding Lordships initiate the disciplinary proceeding Lordship page number 76 charge memo. Lordship's charge memo is 18 Lordships. Same set of the facts has been Lordships basing on the criminal complaint.
Officer has been
Yes, appointed, blood. What's the page number? 11 Lordships. Appointed Lordships and directed to present on 10th blood. Yesterday, I given the instructions.
filed a copy of any similar order that I passed.
Yes, blood. Similar or not? The copy there.
Yes. Notice the admission of the learned repeat. For 6 time to file count. Takes notice and states that without the response. And then it forms the commission submitted. Very thin set of charges. Allegations against which under 498. The civil proceedings are also submitted at that. In the criminal case, a charge sheet has been filed. And in the disciplinary proceeding, we seek to stay off all further proceedings. Habits as a by disclosing the different state is defense is Leonard. However, we will decide that allegations in submission are personal. That the following allegations are potential. Charges in the face. Stay all for the proceedings. All for the proceedings. In the comments. Resume. One second. Just after 6 weeks.
Please, to my lordships.
Yes.
Item number 6, Ramesh, what's up?
Right, please, your lordship. This pertaining to 2018 police recruitment. The petitioner got selected as a CTPC civil, but he belongs to the agency area where the certificate has to be confirmed whether he is staying local as per UAMS number 24. So it got the very first stage, that the district scrutiny, district level scrutiny committee, the DSLC. So that rejected. After that one, he appealed to the government, and government declared it as genuine. That was happened in 2021. But before that itself, they cancelled his candidature because of the medical the unfitness. So therefore, there are instances where they sent it for the remedical. So therefore, the petitioner is requesting for the remedical for him because he is already declared as a genuine aboriginal SC scheduled tribe in the particular area. And he submitted the representations also no.
Yes, where is the representation? Where is the representation?
Millards, page number 58 to 61 minutes. One in 2022 Millards, 10/4/2022. That's page number 5, page number 58 Millards.
Yes,
Get it pending before the government. 16.
page number 60. It's
160.
one. It was issued in the year 2020.
Yes.
When the case. Now, since it's already concluded.
Yes, already. After that itself, Millards, it's GOMS number 35 Millards, page number 17. Page number 17, it confirms Millards.
Because his status was not confirmed. Now that it is confirmed, he wants a remedical. Concerns representations.
Yes.
Want the representation considered or with them for counter and then take care of it?
Representation may take more time, Millards. Again, if they reject again, I need to confirm this one, Millards. So that,
Them for counter.
yes, yes, Millards.
Preparation and it takes it from takes no ways. Same thing, but after 2 days.
Again, the same motion is given. Motion is
In item.
public.
Item number 7, send us
Please, Lord. The petitioner, Millard, his daughter is was the employee of the respondent, Millard. She was died, Millard, on 26/8/2023. Before her death, 2008.
So you want that you're not audible, Mr. Council. Put it there. Mr. Srinivasan, you're not being, not audible. Cannot hear you. We are not able to hear you. Are you able to hear me? Just make a signal. It is also not able to. Okay. You are not audible, Mr.
Sorry, unmute this phone.
Pass over. Chat box of it, pass over.
Item number 8.
And it's a case, my lord, where several unfilled vacancies are there in pharmacist grade 2. That similar circumstances, your lordships were pleased to direct, my lord, to consider their cases against any unfilled vacancies as an intimation. But that in modern, there are around.
Where is that order?
That not filed that. That's all.
Huh?
Not filed.
Not filed.
No. Except the first paragraph and the third paragraph. In the first paragraph and third paragraph, except Rangareddy districts may have to be taken, but rest all will.
So this is not in Rangareddy.
This is in this case, my lord, from various districts they are there. Your lordship would say Rangareddy, they will only be restricted to Rangareddy.
Your lordship say in general.
In general, by deleting the Rangareddy.
Similar order and then page as in P268. Except don't say the Rangareddy district and it is same.
But my instructions will not already the relinquished have been given, 31 candidates are relinquished. Principal was candidates are appointed. Still below the 5.
Okay.
Now 4 weeks, 6 weeks.
Item number 9. Topic of
Yeah, please, my lord. My lord, this is yesterday's matter. My lord, my representation is not being considered by the respondent number 3, my lord. I am being repatriated, my lord, to my parent cadre. My lord, I have given a representation on 25/10/2023. That is IA2, my lord. My lord, yesterday it was coming up for GHM standing council instructions. It was urgent for twice, my lord, for getting instructions.
Dismiss, in that case, there was no representation. Here there is a representation who wanted to be considered before being declared. There was a representation. Huh? Harit Sugar. Yes. So, in a similar matter, I've already discussed it. So your case also will have to be the same thing. Yes. You have the repression number? Give the repression number. You don't answer the case. 303 20%. Dismissed.
My lord, only my representation has to be considered.
No, I have already passed the orders in similar case. Out of these 4 people, I think 2 people have already come and their cases have been dismissed. Yes.
My lord, in that case, representation was not pending. My lord.
But you have no right to make any claim that you should be here now.
No, no,
Yes.
I'm not claiming, my lord, only because my children are studying, my lord, purely on humanitarian grounds, my lord. I'm requesting some breathing time. I'm ready to go to my parent cadre. My lord, I'm not saying that I'm not going, my lord. I'm abide by the orders of this court. I'm only requesting, my lord, some breathing time, my lord, so that my academic year will be complete. My children are studying engineering and 12th standard. My lord,
Both are in
just
Hyderabad
accommodate-
only. What is the problem with your children studying?
They are being sent to Nagar Karnool, not in Hyderabad, 200 kilometers away.
How many
Nagar
kilometers?
Karnool, my lord.
Nagar
200
Karnool.
kilometers.
Nagar Karnool is
Nagar Karnool.
120 kilometers away, not 200. Yes.
My lord, there is one more place in Nagar Karnool. Nagar Karnool is a district.
Hmm?
My lord, interior of the Nagar Karnool, they are being sent, my lord. My lord, so let them consider my representation, my lord. My lord, I'm ready to go, my lord. Just some breathing time I'm asking. That's all.
Same similar order. However, the respondents are also at liberty. Are directed to consider the representation of the petitioner.
I'm obliged.
Item number 10. Gopal, procedural medical health.
What I may please. It
Yes.
is coming for instructions, my lord. But a notification was issued by,
Early intervention.
but he secured 68.3 marks. Instead of showing that, but in the merit, in the provisional merit list I have submitted to your lordship,
They have shown it as
64. And I made a representation also. In fact, The controller of examinations of Usmania page 43 may kindly be seen. But they have also issued a certificate, my lord, secured 68.3. Then next page is my representation. I made a representation also. Wrongly mentioned it. Okay, I missed that.
What is this?
But then, but in fact, page 43 may kindly be seen. It is issued by the Usmania University.
Some formula for calculating and some formula from Google.
CGPA, Mirad, CGPA, they said below 55. In fact, CGPA also mentioned in page 43. Page 43 may kindly be seen. But this is issued by the Usmania University, way from my past. They wrongly mentioned, I think. But CGPA also 6.83. They said it is 55% only. But in fact, it is wrong.
Calculation.
Yes.
His marks was only given in CDPA formula.
They mentioned in the instructions so that is 55% only. But whereas the university has
9.5. Why this? What is the significance of 9.5?
yes.
The following instructions notes. STPA is completed only in all the
CPA is completed.
SGPA is also because that is.
CDPA.
But SGPA means not this cumulative CGPA, blood, cumulative grading points average. That is what mentioned in the notification also. Notification I have filed.
I suggest the last parameter they said now the selection process will be pending. Application will not be consider presentation.
Yes.
Later 1 by 2020.
But taking into account this marks obtained by yes, sir. But this university certificate may kindly be taken into account.
That only.
Yes. But they said CGPA is different.
I do not know that.
Their calculation perhaps it is totally wrong. As is clear from the certificate issued by the Usmania University.
To wait, ask them to file a counter. Will ask them to file counter.
Always, madam. Let them file counter, madam. Yes. But anyway, your lordships are granted status, let them file counter.
2 weeks.
1 week or 2 weeks.
The EPS file.
Because otherwise they will reject my claim, definitely.
According to which there is a formula given for calculating the CGPA. According to which the petitioners CGPA comes 64.89%. The Leonard Council for the petition, however, submits that as per the certificate given by the Usmania University itself, the petitioner CGPA is 6.8 and not 6.48. And with this in the respondents are directed to press conference. The interim order shall continue until the next date.
That's it.
Stop 2 weeks.
Item number 11, Ram Gopal, Civil Service.
Wait. Lord, my lordship's order has been passed earlier in WP number 14662 of 21, page number 27, my lord, for a moment. Yes, I want to draw 2-3 papers, my lord, before lordship. Page number 24. This is the judgment.
Yes, what is the order?
Lord, my lordship is clear specifically directed. Lord, page number 31 and 32.
Reconsider the consideration.
Clearly, my lord, because earlier also there was a direction to consider as per 257. They rejected it. Again, I challenge it. My lordship has elaborately heard this matter by way of judgments and GO 257-66 and passed this order, reconcile this issue. They are not complete this. Then, Lord, I was constrained to move contempt application. Page number 18 for a moment.
18.
18.
Yes.
18, my lord, contempt orders. My lord, orders, contempt order. Lord, may I draw directly, my lord, page number 21, para 6. My lordship has discussed all that. Having regard to the rival conditions of the material on record, that observing the permission of prosecution has not been granted by government in respect of Bapuji, the petitioner hearing 016 would apply. In such circumstances, the response was directed to reconcile the case of the petitioner of promotion. When such were the observations of this court, the response ought to have taken the same into consideration while passing the speaking order. The response have not done so, but seem to have passed the speaking order as per their understanding of the directions of this court. The Honorable Supreme Court in so and so, so and so. My lord held that the matter should be considered to the best of understanding of an authority to whom direction is given, and mere error of judgment with regard to legal position does not constitute contempt for the reason there is no willful disobedience if best efforts are made to comply with the court order. Similar is the finding given in other judgments on which the learned competence system has placed. Para 7. In view of the same, while expressing displeasure at the way the speaking order has been passed by authorities, this court is of the opinion they would have to challenge so and so. No, my lord. Despite the clear direction, they acted, my lord, as per them. It's all, my lord, their choice. They are not implementing any court order of their divorce. Their choice. If they like it, they implement it. Now the present implement order, my lord, is number 16 to 17. The same was the place before the contempt. My lord, page 16 bottom. The 257, my lord, the judgment has been extracted. As per para 6, my lord, page number 16 bottom.
Yes.
As per para 6 of GO 257 GAD, if the charge is one of moral turpitude, misappropriation, embezzlement, and grave dereliction of duty, then the appointing authority should consider as not in the public interest to consider so and so. The 257 para 6 says, my lord, in this case, it's a case of a disproportionate asset of 2017. Till the now, not even an inch has been moved in the criminal case, nor in the departmental proceedings. That was my stand, my lord, continuously for the last 3 years. There is no permission granted by the government, nor any departmental inquiry has been initiated. Now, my lordship may look at my lord, page number 56 to 60 FIR. Page number 56 to 60. This is dated This is dated 19/8/2017. My lord, we have crossed, my lord, 19/8/23. 6 years have lapsed. No charge sheet, no departmental inquiry, nothing. Each has been moved. But till now, government has not given prosecution permission. No GO has been issued. Even you are not calculating what are my properties and assets. You are still at calculation stage only. So where is the question of moral turpitude and embezzlement of? It's a disproportionate case. Then, my lordship may brought me to number 87. My lordship's order, my lord. In case of criminal, because I want a specific direction. Your grievance only that FIR is pending against me. Last para, my lord. In this pending criminal case, the petitioner cannot deny the consideration of his case for promotion. Therefore, interim measure, respond director to consider the case of the petitioner for promotion Nayab Tahsildar. If no action has been taken, respond initiating the disciplinary proceedings or filing of the charge sheet before the criminal court without reference to the FIR. So same order may be accepted.
Yes.
Of the order. Government has the departmental insurance. Accordingly,
So for all these years, now we have initiated disciplinary action.
prosecution.
Not even initiated, not initiated.
They didn't draft the articles of charge.
Prosecution is not.
They want to proceed against the petition.
Nothing, nothing, even till now. Since 21, I am trying a lot for these orders.
And then also the second or third round.
Third round this is.
And in earlier rounds, the earlier occasions, put a directed thing. It's not consider the application. And a trio in December, 66 and 57. Dated 66 and 31, 1981, and this is 10, 6. The response without consider without any application might have rejected signature. In spite of the ACT traps and an FIR being registered, in the years of 2015, no action has been taken. The case and this way, this order it is mentioned that the respondents tend to initiate department proceedings. Because no permission for prosecution is granted, so there's a one and now discussion will be submitted that it's the circumstances. So the deputy number 1491 directed the respondents to consider against the digital data for subject to structure and subject to the criminal proceedings. Since they will as an information score so that consider the case of the promoted.
Assistant food controller.
The post of assistant food controller. Not affects the fair. Still, there is no charge.
No charge.
Fair dated 19.
Not FIR number, my lord, 3. Three.
3 by HCB dash.
Dated 19/8/2017.
However, promotion is granted and is subject to the outcome of the established.
Lord, without reference to this order dated 19/7/24. If you know.
This is fair and also the order, rejection order dated 19.
7/23. Obliged.
Huh? Interim stay of the president. And further direction will consider.
Item number 12, Naganathiru, Chief of Services.
The fly is in respect of 2 counts. Number 1 is house ground. Number 2 is arbitration of CVR.
You are missing it. Where is the appeal?
Straight away, your lordship may kindly clear. Page number 17 is the. That is the allotment for it.
Allotment order.
Uh,
You have
I
asked,
think it has been shown that I have transferred to Nirmal from Hyderabad.
you want to go to
Posting order is at 18, where I have been posted at Mother in Germans.
okay.
And the spouse certificate I have enforced.
You want to go
My
to
spouse, she is working in Hyderabad.
No, you want to go to Hyderabad.
Hyderabad, that is one aspect. The second, the other flaw is senior. You will ask if I kindly take part.
Sir, anyway, I'm directing them to consider both.
Because
What do you want?
this cannot happen always in every case. It is not
What
a
do you
state-
want, sir?
No, see, the order may be set aside. Because in similar case, where the seniority has been dealt with, the junior has been considered, ignoring the case of the petition. Your lordship has.
So this court, you want this court to post you in Hyderabad, allot you to Hyderabad? What do you?
No. Your lordship has kindly.
So I have to direct them to consider your grounds now of spouse loans and seniority.
In respect of this house ground, I am trying to emphasize in focus. The reason being, a policy decision has been taken in respect of this Hyderabad district to the effect that any once a large stock and barrel, all the persons whosoever were working earlier in their spouses' places, that is actually it should not be disturbed and they should be sent back to the places where their spouses are working and their cases are reconsidered. That your lordship will find that page number 45 memo. A series of memos have been given. The last.
They have to consider, see, they themselves are
The policy decision, my lord, and
that's what they have to follow the decision.
also has been enforced. So there in which my name has been conspicuously absent, my junior has been submitted. That is the reason why my humble request is to set aside so that I will not make another. In similar case, your lordship has set aside on the basis of seniority, that also I have request.
Where is that?
Page number 33. Where I could speak about the seniority, where my junior has been considered. So there are files that include the other setup.
Yes.
Here also.
No, but you see the appeal on page 90. 10. Details of spouse rights is already given. And junior, that may not be given actually when you are doing it, you have to exercise and you have to see whether the juniors are being allotted. So that is your duty. Spouse loans, he has to give the details. He has given the details. Where have you considered? Yes. Similar order as page number 33. Appeal is dated 26/12. Both on spouse as grounds as well as seniority. Yes, disposed of.
Item number 30, civil services.
Final info.
Please. Given there, 4 weeks ago. Yes.
Return subjects on 31/8/2020. The return code is dated page 67. And charge was of 44/2021.
You retired in the year
2020.
2020. And charge memo is dated 21.
2021.
Ah.
And inquiry also was appointed. Even with not 7. Page 34, page 33. Due to notes.
Yes.
Paragraph.
Ah.
Second paragraph of 0, page 15, 33.
33.
3 months time is given to submit the inquiry. As on date, the inquiry is not commenced for. Lordship look at the prayer and not the request.
And you're not being paid the
The
pension.
pension is being paid, but your lordship got the several orders to 1 directly the 80% payment of pension. Have enclosed of copies. The lordship look at the main prayer. I'm seeking conclusion of the proceedings for or the alternate let them will. That the conclusion of facility. It is what state proceedings. No, it will commence.
Anyway, you have to conclude.
Yes.
Tell me the time frame. We have to conclude the disciplinary proceedings. That's it. Huh?
Without accepting this.
And you want time?
Then anything more than grant for benefits.
Monday. Let him accuse, let him get instructions. On that day, electrician will be distributed.
Only point is this. Okay.
No, he wants to get instructions and as to how much time.
No, I'm only trying to request the motion is appearance.
Go ahead. Tuesday.
But. I don't know how to indulge in the. So, here's the application pertains to the year 2013. Document issued on 23/2022.
They are not being considered for promoted.
Now, inquiry is complete. In 2020. I submitted further explanation. The only charge which is proved is the negligence. The real allegation was negligence and financial loss cost the firm. So, enclose the inquiry for page 15.
So financial loss is not proved.
Not there. Page 54. Page, it starts at page 50. Page 54, note analysis and assessment evidence. On prevision of the charges, they can sit at 5 to 1. And definitely it's second. Still, authorities have acquired the date. Right of students. The SP summer of the page and published near 2007. Kalwal Lakshmayan about Yashoda were alive on that date. The experts subsequently on 6/4/2007, 23/2009. Prior to conduct a SCS survey by the team in May 2013. The publication of Gazette and students. And the allegation against him, he had not made against one person, he has shown expired. Other person did not pay any remark. Both were paid compensation. Subsequent amounts were recovered. Next last 2 lines. However, the amount of recovered subsequently, no financial loss fixed. So allegation will punishment to be minor penalty. It's more than 9 years from date of incident.
I'll direct them to conclude, take a decision and then thereafter consider your case for promotion.
It's the purpose that will given and
now it has that again. Let them take a decision.
Even the report is censured now, not coming the way. Like what is the Choka will issue 4/2023.
No, see, now that you know, you said it's already completed, they are yet to take only to take a decision.
They are not, that's the difference.
So I'll direct them to take a decision and then thereafter consider your case for promotion. It's not coming in the way of your promotion.
If a lordship is planning to asking orders, otherwise they can consider this. Planning for controlling the inquiry. Or in alternative, they can consider it because they don't do that, this is promotion.
Subscription the commission is seeking a direction for the respondents to consider the case of the petitioner for promotion. The post of night test to that without reference to the disciplinary proceedings pending against the petition. I submitted that in respect of an incident which occurred in the year 2013, the respondents have initiated disciplinary proceedings against the petitioner, and the inquiry has already been completed in the year. The charge memo was issued in the year 2022. But you are 186 stated 23/5/2022. And inquiry is already concluded. Wherein it was held that the now, wherein it was held that there's no financial loss to the executor. And the inquiry was already concluded. Wherein the petitioner, the respondents have initiated disciplinary proceedings against the petitioner, and the inquiry has already been completed in the year 2022. But you are 186 stated 23/5/2022. And inquiry is already held that the there's no financial loss to the executor. with the petitioner, the exigent is submitted that the respondents have not taken any decision, final action in the case, but are also not considering the case.
He made a request for consideration in terms of 251 also.
Now 257 will not take. Yes. Is there for taking a direction for consideration? Not taking another functions. The learned teacher for service is also got on behalf of the students. Having not passed that their disciplinary proceedings have already, that the inquiry has already been concluded, and the respondents are willing to take a decision in the matter. The respondents are pass appropriate orders in the case within a period of 2 months.
The order they have to pass.
Only orders and supervision. Order before 15th of December 2023, and thereafter consider the case for promotion to the post of Naib Tehsildar.
Maybe
In accordance with his seniority and
it's a whole process. If they don't pass orders, they can pass. Already 9 days, 10 years.
accordance with his seniority. And if it is not passed, thereafter, before so on, so this is if the order is not passed for such the case of. So I gave you time up to December 15 to pass an order. If you are not passing an order, then consider this case for permission. Yes.
Right. The petitioner is working as senior assistant. He stood number 2 in the senior list, my lord. Juniors were promoted, he made representation requesting to cancel his case.
Why his case will not be considered?
Because, my lord, he is under currents of minor penalty.
What is the penalty?
Stoppage of increment without cumulative effect.
During the currency of the punishment,
But, my lord, we last already passed in the similar, in the case of censure, my lord, page 27. In the case of censure, punishment, my lord, we last passed out by following the judgment of the division bench.
yes.
Lordship, censure also bar for promotion 1 year. Lordship, that is also coming.
There is a writ appeal order 11 days.
Yes.
Which I have followed to direct them to consider.
Lordship,
Let them consider, I am seeking to consider.
only representation pending, my lordship. Before that is page number, my lordship. 13.
Where is the representation?
Yes, ma'am. Representation is page 13, my lord. 13, 1-3. My junior's name also extracted, who are promoted earlier. Page 14, my lord, all the 40 juniors are promoted.
Direct your representation to be disposed of. Lordship duly taking into consideration this order.
Yes, minor penalty.
Requesting the petitioner taking a direction to consider to the respondents to consider the representation of the petitioner dated 2010-2020 for promotion to the post of manager grade 2 in one of the existing agencies.
Okay.
The petitioner came from made 2010-2020, giving the details.
Fortress.
It is submitted that the petitioner has been rewarded minor penalty of insurance, and on that ground, the guide to the petitioner is not being considered for motion. He submits that in similar case in the PP number 22191/2020, an interim direction was given to consider the case of the petitioner therein for promotion in the light of the judgment of the division bench of this court in the appeal number 1150/16. It's similar direction. It's in the stage.
Yes.
Observer who has objection to disposal of the material. By no objection to the direction to be given in the points for disposal. Having about this court in second that it's a response. And it's number 2. To consider the representation. Section 2010, 2050 and first one. Interim model is for double to 17 hours. Part of appropriate orders there. In 3 weeks.
My lordship, may I say 6 weeks, maybe books, my lordship, all are busy with election duty.
Why should they be busy with election? Election duty do they have?
Last we add that by taking into consideration the orders passed by. Yes, hopeless.
6 weeks.
Number 16, Bhaskar, equal services.
Included by the included order, my lord, at page number 14. Page number 14, my lord, where the compassionate appointment is rejected to the petitioner. My lord, the instant petition is filed, my lord.
Rejected.
Rejected, my lord. That is a rejection order, my lord, page 14. It is rejected on the ground. The ban on recruitment means compassionate appointment also. My lord, a similar order was passed, has come up for consideration, my lord, before this Honorable High Court, and the order is at page 40, my lord. Page 40, and the operative portion, my lord, is at page 48, para 14, my lord. The contest or learned counsel will respond to each election party, my lord. Each college school is different. Unit and petitioner's claim cannot be considered on the ground on the ban of recruitment. On the other hand, in their counter response, admitting that despite a ban, they have considered compassionate appointments in similarly situated cases and given appointments and in view of the same, the impugned proceedings stated 29 so and so are liable to be set aside, accordingly set aside. And we have directed consideration to reconsider the case of the petitioner there. A similar order will.
Page number 12.
Yes.
In the light of the judgment.
Yes. This file challenging these. Order of rejection. Its application for compliance to point. Respect of her daughter. This is the wife of simple point. The request that the daughter be given compassion. Said application has been rejected by order. What is the date? The order?
Date of the order, bill.
29/7/2020. 29/7/2020. It's submitted justice similar matter but arising to the scope. I have not that by orders dated 16/3/2022, the directed respondent very confused by the six similar for services one, however, point out that there is a representation of each plan. Okay. 8/7. What is this? Your representation is dated 3/10.
310.
These are the considered by. Of the resolution. Refreshment disposal of the declaration states the direction of respondents to reconsider the case by looking into the contribution to the petitioner of representation dated 3/10/2020. Also, by taking But I'm also into judgment. Oh, number 177. 16. Forgive the order. Can be annexed. Already done. In a period of 6 weeks from the date of the conference.
Number 17.
The Education Department, my lord, school is HGTs.
Hmm?
HGTs and my lord, other category of teachers. My lord, this other category of teachers, my lord, like a music teacher, craft teacher, sewing teacher, they were separate posts were there during 1993-94. It has been, my lord, discontinued from 94 onwards for the last 20 years. My lord, she was appointed during 93 as a music teacher. And she was allotted to government management school at DO office, Khammam. She is supposed to be working in the government management schools only because local bodies and government who are there, my lord, coming up for number of cases. So while working, my lord, due to transfer, she was posted to Jila Parishad School at Madira. For the last 20 years, she is there only. Now 317 has come. 317 allocation also, my lord, she was, because within the district, she was allowed to continue only in Madira, but she was not transferred to Khammam district in the DO's management. Then, my lord, she approached then 8080. My lordship get by number 13, order dated 13/12/2013. My lord, I read this. Under the facts and circumstances, I am of the view that the response should be directed to pass orders on the so and so. My lord, point number 2. For the reasons stated under point 1, the OA is allowed. Set aside the implement procedure dated so and so by the respondent with the direction of the respondent to pass orders to the applicant without a shelter under the pendency of case regarding unification of service rules of teachers or government management, Jilla Parishad management before the Honorable Supreme Court. The applicant was initially selected and appointed government management schools where she worked for 8 years. From that, right from 2000, necessary order she will pass with so and so. Accordingly, she was posted back on deputation only. In the reference third set, Commissioner has furnished the proposal for transfer of Srimati K. Shashishri, music teacher.
So what happened after that?
They are not only for deputation for 3 years, then again posted back. She is still there in the Madira. Husband is working in Hyderabad. At least if there in Khammam or nearby Khammam, even she asked for a deputation to Hyderabad also. Music teacher, music, craft, singing teachers, there is no work at all. Nobody learning nowadays in the schools this category. Since they were appointed, they are taking some other work from these people. But she was not compelled to work in Madras for such a 20 years. Before I made representation then also, my lord.
Where is the representation?
The present representation, I want implementation of this 13/12/2013 order only to consider her case back to my lord. I'll make representation, lordship. My direct, my lord, I'll make representation. Let them consider as per memo dated.
Then you come. After 2 weeks, this topic.
The motion list. Let go both the bulk. Motion, I'll try.
Make it come.
Yeah.
You haven't even made any representation.
I want implementation of the tribunal judgment. The government already issued memo. That may be directed to implement. That may be implemented. It's a memo, and already tribunal judgment is in my favor. Again, I make it.
But what has flown? We do not know the factual.
It's only motion list.
Just after 2 weeks, that's your motion.
Bless.
May please, I'm appearing on online matter, your lot may be kindly consider. The matter pertaining to promotion to the post of assistant director. The petitioner is now working for the veterinary assistant surgeon. There is a deficit in the promotion in the SC category. The petitioner made a representation to the respondent requesting to consider against the SC vacancy, page number 26/21/2023.
Why it is not considered? When did you make the representation?
21/2/2023 after coming to notice there is a deficit filling of the promotion post in the SC category. That was accepted by the first respondent and attached to second respondent, page number 39. 39, madam, you lost me categorically accepted that director of annual husbandry. There is a deficit of 2 points from the pillar in the promotion post SC category. Page number 39 starts from relevant portion 41.
What is the surface? Surface?
Page 41, minute paragraph 8, minute, your lordship can come.
No, ultimately, what is this recommendation?
Recommendation, but there is deficit in the promotion to SC category. Petitioner is eligible for promotion, only one candidate is there. His case shall be considered. That is the pending before the government, my second respondent.
Yes.
Lordship, I'll get instructions, Lordship.
What I'm requesting, Madam, with regard to the
Recommendation is dated 26/9.
Yes, Lordship.
At the request of the GP services, to get instructions. Just after
Next week, Lordship.
20th?
Oh, bless.
20th.
that is motion list, Madam, your lordship.
Yes. Yes, next.
Item number 90, number 12.
Contract with part-time correspondent. Beyond 60 years of age.
Yes, ma'am. One was wherein in the year 1996 itself, an advertisement has been published, wherein specifically
That Prasar Bharati.
Yes, ma'am.
I have already passed orders.
Passed an order
Ah,
without comparing that fact.
there is the response to consider the representation. Now they have disposed of the representation.
But they don't of representation, without appreciating the facts. There are of reasons. So in this royal logic study of the report keeping order. Other than striking the prayer from my reputation as well as order of your lordship, the record course of your lordship.
You have no place actually.
Appointments are permitted to pass on the instructions from the latest.
Purely contractual answer.
He has attained the age of superannuation and according to the latest guidelines, 22nd December 2022, is not an eligible after 60 years. Any government employee after 60 years is not permissible and moreover he is a PTC. And latest guidelines clearly states that he is not eligible. They are referring the old ones, whereas the latest guidelines, it states very clearly that they are not eligible. Lord, I will get the instructions in case you are from the ministry. Kindly for which time may be granted. Lord, I will get.
It's quoting madam. Apologies, madam, it's page 24. Hello, the advertisement published by them. Thereby, the penultimate paragraph.
What is the date of this advertisement?
Date of advertisement. Basing on this advertisement, we have made an application. We have been selected for the place of parking. The logic may kindly.
What is the date of this advertisement? 1996, perhaps. Now, latest instructions are not
extended. Basing on this one. Hello, we have already produced a medical certificate.
See, their order also mentioned that it is solely at the discretion of the competition authority. Since the petitioner submitted representation, I directed them to look into it.
They are not eligible. The latest guidance clearly states that after 60 years, after attaining the age of the superannuation, they are not eligible.
The contract employment is not a regular employment.
11 months agreement, every 11 months he himself states as he has attained the age of superannuation. It is not possible. Excepting the constitutional posts, other posts are not under government of India. He has to retire after 60. Even
presentation.
Even
Please don't interfere.
Yes, Milord, sir.
Yes, speaking order, speak volume, logic, page 14 melons. But other than the extraction of prayer and current portion of the lordship's order, there's nothing on the income speaking order.
There's nothing more to tell you. You have crossed the age of 60 years. Yes. The petitioner is seeking, is challenging the order that's on an intent and rejecting the representation. There's a second order of litigation. And then it also submitted that the respondents, that the income order is without giving any reason. It's passed without giving any reason. That is the real notification. Directing the response to the representation. It's so, has already observed that it is that engagement registration is not a regular appointment, but it's contractual, and it is renewed from year to year. And that's the modified scheme, that contract period cannot be extended beyond the age of 60 years. So that renewal of the contract for Contempt beyond 60 years is solely at the discretion of the competent authority. The authority will say consumption, not to extend the contract beyond 60 years. You will see there is no very good discretion in this. The pressure the parliament.
Much obliged.
Item number 20. If you manage it, time.
My lord, it's very not being kindly push it back to
Family pension.
Other also 62% physically handicapped person. And assisted the patients were seeking consider the patient.
8924 it isn't. 23, right? Yes.
The payment is 40.
Yes. Well, there is a recommendation also. Page 16. So you can consider that passwords. And dispose of it. I recommend them to consider your application and also the recommendation given by the audit officer. Yeah, but let him be there, council be there, he's not there. Go on next week. Yeah. On its next week.
Item number 21.
I filed KV against award of labor. Next week.
Yes.
May I please, my lords? I'm appearing
Yes.
online, my lords.
Yes.
My lordship, petitioners makes an application for withdrawal of resignation to the depot manager, my lords. Depot manager says, I am not competent. I will forward your application to Deputy Chief Personal Manager. Deputy Chief Personal Manager accords permission for withdrawal of my resignation and asks me to join duty as a junior most cadre conductor. I'm happy with that. Now, my lordship, the depot manager says you join, but you return back all the settlement amount that you have taken 1 year back. Now, my lordship, once the depot manager says he is not competent to apply his mind to the application made for withdrawal of resignation, having given up his jurisdiction to his boss, when his boss says you join him as junior most cadre conductor, now this person exceeds the jurisdiction and says you join back, but you give back a settlement amount. Lordship,
Have you joined now? Have you joined or not?
He is not letting me join, my lord. That is my prayer, interim prayer.
So with regard to the repayment of what amounts he got, that we will decide later, but him to join. Actually, once you withdraw the resignation letter, he should be permitted to join in the same position.
Page number 12.
Page number 12. When did he resign?
22/8/2022, my lord.
And then when did you make the, it was accepted?
Yes,
After acceptance, you wanted to withdraw.
Accepted.
Accepted and paid, and then thereafter he wanted to withdraw.
After 15 days, he realized and he wanted to withdraw.
Lordship, can you see page number 10 once?
He said you please pay back the amount received.
No, who has to say? No, that you should do it when you are permitting him to withdraw the resignation and rejoin, then that officer should say what should be the.
So we have issued letter. That's not the.
Lordship, can you see page number 10 once? I'll just read.
Page 10.
Yes.
Becomes junior most in the cadre of conductor in the region.
Yes. Now this order is given to the depot manager to do a necessary action as per this letter. Now, Lordship, the order which is under challenge is page number 9. Lordship, is page number 9. Now, your Lordship, see, as per circular guidance, you have to pay back the settlement amount paid to you so as to deal with further into the case. Therefore, it is requested to pay all settlement amount within 7 days. This person says, depot manager who passes award, the order says he has no jurisdiction. Has given to his superior officer. Superior officer says, you join him in junior most cadre. Now, this person exceeded his jurisdiction, my lords, stating that you have to pay back settlement amount is not.
This amount, whether he has to pay back, whether you can call upon him to ask him to pay back, it will be decided. Meanwhile, permit him to join.
I'll be deeply obliged, my lords.
It has to go together. Both should go together. Lordship, can you see page number 12 once? You don't admit.
What admission?
Petitioner. Now, Manavi Himanagar Maku Solution. We can settlement amount pay చేయమని 2023 ఇచ్చిన కానీ అందులో మీకు సెటిల్మెంట్ అమౌంట్ ఎవరికి ఎంత కట్టవాలనో డీటెయిల్స్ తెలియడం లేదు. కావున దయచేసి పట్టవలసిన సెటిల్మెంట్ అమౌంట్ డీటెయిల్ గా ఎవరికి ఎంత అమౌంట్ కట్టాలో క్లారిఫై ఇవ్వగలరని నా యొక్క ప్రార్థన. His own admission, he is ready to pay it. We are saying you please pay it.
I am not saying I am ready to pay it. I am asking for the breakage. The request is for breakage. I am not asking that I will.
All right, we'll decide that whether he is liable to pay, how much he is to pay, and all that. Meanwhile, permission to join because your this letter dated 10, page 10, office order permitting him to withdraw his resignation letter doesn't mention anything about the repayment of the amounts paid. That order should have said. 9 is not the depot manager is not competent to accept the resignation or permit him to withdraw the resignation. Who has to pass the order? It is the deputy chief personal officer, isn't it? He has permitted him to join. So if any condition is to be imposed, it is that person, not the depot manager.
Actually, balance the order.
That's why I'm saying that we will decide later. We permit him to join in accordance with the competent authority's order. Notice for admission. I'm not disposing of the resolution. I'm keeping it pending. You can inform. Notice for admission. Then standing for Srinivas.
Yes, no.
Yes, Srinivas. Takes notice to have that sponsors at 16. But the petitioner was had submitted a resignation letter, was permitted to retire. However, the petitioner has submitted a letter subsequently withdrawing the resignation. So submitted the by orders dated 14/9/2023, the petitioner was permitted to withdraw the resignation, subject to the condition, and rejoin the service, subject to the condition, he becomes the junior most in the care and protection of the recruitment. So submitted that for the petitioner intended to withdraw the Recruitment, the picture respondent, the third respondent to require the petitioner to pay back the settlement amount paid. Submits the ethical manager, third respondent who is not a competent authority to make such, impose such a condition. This issue requires detailed hearing. As an information, this would direct the respondents to permit the petitioner to join the hearing as directed by the second response by the Deputy Chief Personnel Manager. 49. This after 4 weeks for counter.
My request is page number 12 may be referred one.
Page number 12.
Page number 12 says I am ready to pay.
That is part of the record only now.
That may be referred.
The learned standing counsel for the first point that the petitioner himself had requested, had accepted the previous to meet the pay and access to the details of the pay. The pay at the final detailed hearing and yes, next.
4 weeks.
4 weeks.
Number 20, Venkata, legal services.
Connected to batch, my lord, that medical batch.
Poster.
Obliged.
Milordship, I am the petitioner, Milordship, in the 23rd matter, Milordship. Already my senior mentioned in this matter regarding to the connect with the batch matters, Milordship.
We should have a coordination meeting for this. Who is going to mention virtually?
I've already told them, my lord. Sorry, my lord. Apologies. Apologies, my lord.
What is it that you're asking? There is a settlement with the brain, the brain is what? There is a settlement of the there are five different that have been exposed in terms of this and 23 times 2023. Page number 60 is the outer cover. Of their four users, drops, then the constituted as a husband, she was declared struggle, faith, and humans are enough by providing dependent employment and placed by the community to pay for providing employment has been dismissed and treated the company and is not eligible for payment of ransom by amount of 2 lakhs 24 months, whichever the SDH. They have this order saying that now anything else. On voluntary retirement, you are eligible for either dependent employment or monetary benefit. Yes. So get instructions in the matter. Why you are not saying? Instead of yes, not to put admission, the rendered study box, then it's time to get instructions. Instructions and file a comment list after 3 weeks.
Item number 25, non-time, services.
Permitted appearance. Petition relating to recruitment. My representation is at page 45. There is one post, you'll also see page 44. There is one post which has been kept aside in WP number so page 44 after the eligibility list. Only requesting that I'm also having the similar facts. My representation may be considered. If they find it not appropriate, they may dismiss it. I'll take steps to include in the writ petition also.
Why should they be given the opportunity?
The writ petition is still pending, elections. The writ petition is still pending.
Pending, then you get it there.
We'll take steps. That's what I was just telling them.
For again, your
Unaware of that. Unaware. Similar candidate, we are only asking to be considered in recruitment.
Then in that case, if there is a direction to reserve one post, the court must be satisfied, must have been satisfied about the right of that person.
Absolutely, Your Lordship. In fact, that is one of the suggestions I've already given. We will take steps immediately to be included in that case. In that case, they can just consider and pass out, they may reject my
Why
representation.
should I put the expression
No issue.
without your establishing your rights?
Fair enough, I'm ready. Lordship may then permit me to withdraw with liberty to file implead there. I'll file implead in that writ petition.
And the request to the letter for verification, expense has been brought, liberty file, implead which shows in WP number, what is the right of profession and which one will take?
In WP number 33714 of 22 at page 44, Your Lordship. Point number 3.
Yes. Expenses.
Number 26, Kumaran,
That is not. Instead of Bipul Mallar was working as senior assistant Mallar in the office of assistant commissioner Mallar. When Mallar he had expired on 28/3/22 Mallar. Right was in service. Subsequently, the funeral expenses was transferred to the account of the petitioner Mallar, which is at page number.
But they have not released the pension.
As on today, they did not release the pension Mallar.
When did he die?
He died on 28/22 Mallar.
22.
22, 18 months has been lapsed, my lord. He made many representations, my lord, but till today, no pensionary benefits has been released by the respondent.
Yes. What is this 31182? Random? Constitution.
Page number 22, this is a employees enrollment form, HIGHCOURT, my lord, teacher. The name of the petitioner.
Take a chair or a chair? Huh? There seems to be some problem in the post title which is attached. And the court fee paid. So I'll post it for Tuesday. Let it be corrected. Tuesday and motions.
item number 27 to 41. Particularly effectiveness. Item number 28.
Allowed. No further orders required. Closed.
Item number 29. Constitutional.
Liberty closed.
Item number 30.
Next week.
Matter became infectious, lordship.
Huh?
Infectious.
Infectious. Learned policy for the patient subject to the regulation only. Dismissed as plus one.
Item number 31.
Rejected. Liberty to the charge. Close with you. Rejected, huh? Same. That's liberty from the charge. Yes. Same, similar or rejected. Close with liberty.
Item 34. Segregation.
Yes, same, similar or.
Item number 35.
Yes. Yeah.
Item number 37. Ramu. Students' education.
Next week.
Item number 38. Contempt.
Close with liberty.
Item number 39. Ramu.
Rejected. Same.
And now 40, check out.
Take it up, that is right. Same, season. Close to 3.
And now 41, go back.
No further orders are required in this matter.
Council for the city submitted that. No further orders are required in this matter. Close. As in. Yes.
And number 42, assistant services.
Seeking only consider representation made plain and interpret, not challenge of rejection order.
What are parts of this?
My lord, sir, our prayer is very clear to the extent for passing on the releasing and benefits, my lord, sir. So what my friend says is only telling the representations, it is not an issue, my lord. We have specifically made a
parts over.
And number 43, go back to our said, keeping the registration straight from.
I'm exposing of the repetitions. In the view of the same, this court does not find any reason to interfere with the interim order. However, in the interest of justice, this court deems it fit and proper to direct the response to consider the apology tendered by the petitioners and also the explanation with an open mind and take a decision without being influenced by what was stated in the show. The writ petition is disposed. Yes, orders are passed.
May I make one submission, my lord? In this matter, the respondent filed a counter. In the counter, the respondent with regard to maintainability, when they are taking, they have stated that it is a private institution, my lord, which is.
No, that I have not dealt with. I have
You are
mentioned
not-
that both of you have taken this.
Yes.
And without prejudice to that ground, I have disposed of this matter.
Yes.
Okay. The decision will be taken in the other repression. Yes. Both of you have argued. That I have mentioned here.
Yes.
Obliged to you.
And number 44, speak on. Give that one.
and now in the suspension of the constable. I bet your application is that it's for regular things.
Are you arguing the matter or responding? Then please take a mic.
Why this?
That's
No matter pertains to Milord suspension. Now, thereafter, we have amended our prayer, Milord, only to the extent of disciplinary proceedings may be stalled. Milord, both. Yes, ma'am. It was filed on 15th August, Milord. Amendment. We have entered with a no objection. Milord, the matter is like, Milord, the articles of charges were issued on 16/12/2021, Milord. Similar charges, they have made two charges, Milord, saying that he was.
So you want the articles of charges to be set aside?
Yes, ma'am.
On the ground that on the very same set of facts, another criminal
Yes,
case
ma'am.
is.
Yes, Milord. And now they have appointed a disciplinary inquiry officer, Milord, recently on 6th July 2023 to conduct and complete the inquiry within 2 months. Milord, I'm only seeking the stay to so far the disciplinary proceedings inquiry, Milord, because the criminal case is pending and the inquiry is completed and the charge sheet has to be filed. Milord, both are the similar, articles are same.
So you are asking for interim measure.
Yes, Milord.
Amendment petition is allowed. Yes. Yes.
Yes, just now I passed on, Milord. I think my clerk has missed it. I have mentioned in the amendment petition, Milord, para 5, the same thing that the new inquiry officer was appointed on 6th July, para 6, Milord, in my amendment petition.
Yes. What are the charges against you?
Milord, that I am involved in a criminal case. Lord, he abetted to suicide, my lord. The charge is like this.
You said of who?
One Alekia is nothing doing with whoever had died, her husband has made a complaint saying that she died because he threatened her through phone call. My lord, there is no evidence.
All right, yes, come. Your order has this page number. Sixty. Fashion, take it the days. The disciplinary proceedings and inquiry officer has been appointed when proceedings dated 6/7/22. And the participation in inquiry with the size is defense witnesses. Therefore, they shall be fixed for the proceedings. And proceedings pending inclusion of the minutes. Missed after 6 weeks to count.
Obliged.
Number 45, put it correctly. Put it on.
Lordship indeed. Eventually, Lord. So can you eventually?
Item number 46, actually, we are taking a cooperation.
May it please, your lordships.
Yes.
The present writ petition is filed challenging the termination order, your lordships. This is the second.
It's fine.
No, your lordships, no. This is coming for the second time, your lordships. Earlier only notices were issued. Your lordship may see this is the second round of litigation, my lords, wherein
Has to be filed for termination.
your lordship may see there is a procedural lapse, your lordship. The section 55 clearly says that if there is any misconduct or if there is any cash discrepancies, the chief executive officer or the president, whoever is maintained,
The date of the termination order.
2017, your lordships. Your lordship, there is a procedural lapse, your lordship.
To file counter list after how much time? Anybody who's there?
It's working under the control of Primary Agricultural Cooperative Society, Lordship, you have fine.
So notice has gone to him or not?
Notice issued, personal notice is also sent, your lordship.
Have you filed proof of service?
Yes, your lordships have also filed proof of service.
All right, for conference respondents.
Your lordships may take at least 2 weeks. Because, my lords, the procedure clearly says that the registrar has to look after all the accounts after putting on notice the chief executive officer, but no procedure is followed, my lords. And
It's a case of 2017.
yes, your lordship.
People have to go through the records, find out what happened and then submit something to the.
The termination order itself is very clear, my lords. It goes for 5 or 6 lengthy pages.
Though it was very clear, you did not find it, fit to file.
No, my lord, the client has come just. I'm obliged, lord.
Any comment is not against the council, it is only against the party.
Yes.
Sorry.
Item number 47, Sandeep Prasad.
May I please speak? No, yesterday's matter, my lord. Promotion.
Yes. Motion to the page.
Page 12, my lord.
Any disciplinary proceedings against?
No, nothing, my lord. Page 12.
Have any instructions? Yes.
State as itself candidate
The training is mandatory. You have to have the training, they say.
No, I am completed the training also, my lordship. Kindly see page 12, my lord.
Yes. This mandatory training, have you undertaken?
My lord, as far as the training is concerned, my lord, I have stated in my representation, I submitted, I have completed the
You are referring to that 1 month training.
yes, my lord, training, Central Malaria Laboratory. My lord.
Say it's not sufficient and they have informed you already.
No, that is on level 11, my lord. That's not.
11/11/2020.
My lord, till date, they have not given any this thing. My lord, I've submitted my representation, my lord. Till date, they have not passed any orders on this representation. My lord. That's my concern.
They have already informed you. You have to have that mandatory training. You have not undergone the training. What other information you want from them?
Recent reference also, my lord. Lordship, I kindly see where in the memo I filed. Lordship, I kindly see the memo I filed, my lord, by USR number.
What is that?
109847 of 2023. Lord, Lordship, I kindly see page 2, my lord, wherein the Directorate of Public Health and so and so.
Your application has been forwarded. That's it.
No,
What about
it is.
they say they have already informed you about the mandatory training required. What is your answer to it?
My lord, moreover, one thing, my lord, my humble submission is,
Do one thing, let them file
well,
comment.
not that one. 45 years, my lord, I have not given promotion for, there is a GO, my lord. For first promotion, if I am crossed 45 years, then no need of any qualification for promotion, my lord. That is the GO, my lord. That's,
You file all that, let them also file counter in the mandatory.
my lord, only 1 year, I am 60 years old now. My lord, Lordship, tomorrow, my lord, I'll get the GO, my lord.
Right away. Just because you have completed 6
Well, the GO I'll place it before your lordship, because well, one promotion without required qualification also, if I am 45 years above, I am eligible for promotion.
5 years above, 15 years back. You are sleeping all along now. And at the verge of your retirement, you want the promotion to be given like this. Without mandatory training.
My lord, the GO says, my lord, that is only my concern, my lordship, I kindly see. Tomorrow, my lord, well, next week I'll submit the GO, my lord.
Until 1 first.
Published.
Yes, thanks.
April. The petitioner sir was working as the assistant executive engineer, municipal health and public engineering service. The next promotion is the deputy executive engineer. But there are along with this post, there are other 4 categories are there, pay 68 not getting. Our categories that the pay 68 is the concerned rule.
Not the promotions.
Yes, ma'am. Promotion to the post of the deputy executive engineer.
There is a change in requirement.
Pardon me?
There is a change in the requirement of qualifications.
No, not requirement. Along with there are total 5 categories to the for the promotion to the post of the deputy executive engineer. But for us and the other category, it is only required 3 years service. Whereas the other 3 categories, they require 5 years of service. We completed the requirement of 3 years in the 2021 parallel year. Even in fact, 1920 and 2021 parallel. 1920 also we have completed. 2021 they completed the 3 years of service. But purposefully, and the government is directed them to informing the decision of the Honorable Chief Minister that in all departments the promotions to be completed by 31st of the January 2021. In spite of that, purposefully but to include the other category people, instead of preparing the year-wise panels, now they are trying to simply prepare the rule 6 amendment clearly states. Ordinarily it has to be prepared, but taking the 1st September, the determining qualification is to the 1st December. In such case, we are the qualified in the respective panel year. Now the panel years they want to prepare the clubbing all the vacancies to the relating to the several panel years. But that is held to be bad in fact. Only unless a conscious decision is taken, in this case, the conscious decision is taken to fill up the vacancies. If a conscious decision is taken by the government not to fill up the vacancies, that is a different thing. But here is a case where on contrary, there is a direction from the government to the various head of the departments and other authorities to fill up the vacancies by 31st by way of promotions by 31st January 2021. In spite of that, under the guise of some other rules, the last time for this purpose only
Just now received the instructions. Yes. Just now received the instructions, Meenakshi, only 2 minutes back. Maybe taking it tomorrow, Meenakshi.
Next week.
in the same list, in the urgent motion.
Yes, please.
Cost services market issued and the respondent council is the state sanction Babu. Also the market.
Yes, sir. Copy.
I'm sorry, madam. I'm sorry, but instead of tomorrow, 14th you are speaking.
Just said next week.
14th in the urgent motions.
Already చాలా matters ఉన్నట్టున్నాయి. It is on 16th, same day.
16th in the same urgent motions.
The name of Mr. Sanchal. Then another count 6 times 5 proof of service of notice of responding of form. Standing process there. Another possible addition 6 times 5 proof of service. Respond. Please stop what we have. On 21st. Yes, next.
The mother is thrown out and like emotions.
Will be in the same place.
Chips, bro, open with this one.
Seen as after on.
Is it date?
Today is not the date.
Sorry.
Who is Hellam? The chief AG is up here. It's office. Yes, Mr. Sudhir?
My lord, am I audible, my lord?
Yes, you are audible. Now, adjourning it to next week, we'll take it up next week.
My lord, I
Subject
only
seems to be engaged.
my lord, Lords may kindly see the docket, my lord. It looks as if I'm trying to be snobbish, but Lords may kindly see the docket.
Yes, we have a booklet of adjournments.
That's what, my lord. I'm always ready, my lord. I've been ready in this matter. At any rate, my lord, the lordships have given extension of interim audits. So last time, my lord, it sounds purported as if it's extended until further audits. But now what is coming up is IF4. The lords may kindly have a glance at IF4. He retired, my lord, in August 2022, he retired, my lord. For 1 year, 3-4 months, he is without pension. I'm only asking provisional pension. They were willing to dismiss me. They wanted to dismiss me in this honorable court rescued me, my lord, twice in 2021 once and 2022. Earlier, I had faced 5 inquiries. Everything was closed. Again, the same person, my lord, one who was yesterday involvement.
All right, we'll take up next week on the 23rd.
At least IF4 may be ordered, my lord, is without pension.
We'll consider on that day.
Please.
The model granted at the end.
Your Lordship may say finally, my lord, they have taken several adjournments.
But every time Mr. Sanjay will be engaged in another division.
The last occasion we are ready to.
Then what happened last time?
No. My lord, with respect, my friend Komat Reddy, it's adjourned, my lord, at least not after filing IA, it's adjourned about 12 to 15 times. Every time I'm ready, my friend is not. But I understand, my lord, he is from Magistrate Advocate General Office, but this is also a matter. I am also an employee suffering. Your Lordship say finally, my lord, no
Finally,
further.
on 2311.
In the adjourned motion list, my lord.
Yes.
Much
My lord,
older.
I appear for the petitioner, my lord, in 52. Yes, they both go together.
Yes. Who is appearing to the respondent?
My lord, sir, pleased to grant stay, my lord, in September 2022. Issue is, my lord, whether disciplinary inquiry and criminal trial can come. Yes.
Yes. What is the issue here?
My lord, issue is, my lord, whether disciplinary inquiry and criminal proceedings, my lord, can continue with respect to the same matter. My lord, sir, pleased to grant stay, my lord, in the disciplinary matter. After that, my lord, when stay was granted in item 52, subsequently 53 came to be filed by A8, my lord, who is also another employee of the Railway Protection Force. In that matter, my lord, sir, pleased to pass an order. Lord, may I pass on a copy of that order, my lord? This is following the order passed in my case. This is the order passed. Learned Standing Council, however, submitted that a counter has been filed and declared upon various judgments. Having regard, my lord,
Yes.
this order is until conclusion of criminal proceedings in crime number. But my lord, in my case, my lord, this is following post along with 37100. That is my writ petition, which is item 52. In my case, my lord, they filed vacate petition. Here, there is no objection to the, my lord, extension. There is stay continuing until, my lord, disposal of criminal trial. And in my case, my lord, every time, my lord, whenever it is listed, when I am ready, my lord, the matter gets adjourned and they want only a limited stay. Right now, my lord, I am ready to proceed further in the matter and argue the writ petition itself. Since counter is filed, subject to my lord's convenience, and my lord's board, my lord, I am ready to argue the matter. It's a short point for it, might not take much. No. Kindly see, my lord, the docket, my lord. No question, my lord, of me taking time, my lord. I have been ready, my lord. I have been engaged to argue this matter. Subject to my lord's convenience, I am ready, my lord, right now. Won't take more than half an hour. Should I be able to support it? Since September 22, my lord, stay has been extended.
Yes.
Right now, my lord, right password. Right now also, yes. Wait.
For what?
My lord, let that be deleted, my lord. I will argue my case. No, my lord, he is, my lord, he is.
See, as you pointed out, in your case,
See, my lord, this here. See the irony of the situation.
he got it subsequently.
Yeah, he got a better order. Yes, my lord.
When do you want next week? Not spelling thereafter. Come on, 16th. Stainless. Case of this 52 items to 57 should not have cancelled. Yes. Okay, 16 month.
What is this? He can see, he has read that order just now I have shown. In the teeth of that order, they made. They filed in that also, counter is filed. And I am saying I am very.
Can't be extended, beyond a particular period. After
In that case, my lord, your lordship have seen the order. Your lordship has passed that order.
Not Mr. Rashid.
Following him, no, my lord, following my
after your order.
Yes.
The court has passed the order in the other case.
Yes, yes.
Okay, doesn't mean that, after they have filed a stay vacate, I can extend it until further.
No, I'm not saying, but I'm not saying that.
Okay, level.
My lords, I'm sorry. Yesterday I missed out the case because it was showing GP services to me, lord. I'm sorry, my lord. And in fact, my lord is coming for the counter, and now they have filed additional material papers, my lord, which has to be looked into. There are 2 complaints raised against the petitioner, and as the charges of sexual harassment were proved, he was terminated. He is a contract employee. Now, my lord, the latest representations of one of the complainants has been filed saying that I made a false complaint. It's need to be looked into, my lord. Your lordship may grant 2 weeks. So
My
that,
lord, not just that, my lords. My lords,
and there
one
is an
other-
interim order also, my lord, saying that that particular post
My
is
lord,
not to be filled up.
definitely there is an interim order, my lords, but my lords, one other aspect has to be looked into before adjournment can be granted to 11 GP, my lords. My lords,
Has it been
my
allowed?
lords, may I kindly have a look at page numbers?
Yes.
My lords, may I kindly have a look at page number 21 to 25, my lords. For a moment, my lord. 21 to 25, which is an alleged inquiry report, my lords.
No, 21 to 25 of the additional papers.
Of the IA number 2, my lords, additional material papers. I'm sorry, my lords. This is an inquiry report, my lords. Now, my lords, may kindly once have a look at page number 22, a paragraph which reads, further the committee, my lords. It says, the inquiry has been conducted on 1/11/22 at DCPO office, Bhupalpalli, my lords. Now, coming to page number 25, my lords.
25.
Which says who are the committee members. My lords, I'll not take a minute, more than a minute of your lordship's time, my lords.
Yes.
Number 25, item number 3. Number 3 is Srimati N. Moti, who signed on 10/11/22, my lords.
Okay.
Now, yes, my lords. Now, from page number 26 until page number 29 is the daily tour record of the Srimati N. Moti, my lords, where she was there.
Okay.
Now, my lords may go to page number 29, my lords.
Yes.
Which establishes, my lord, last 3 columns, my lords, November 1, 2022, the date of inquiry, my lords. Which says she was present in Erramanzil, Khairtabad, my lords. All 3 on the 1st of November. And she has signed a report telling I have been present in Bhupalpalli, which is more than 300 kilometers away.
No, but this is on 10/11 she has signed it. Okay, the inquiry is supposed
My
to
lords,
start
the inquiry,
on
my lord, inquiry is conducted on 1st November, my lords. That is why
So how did she participate in the inquiry? So how did she
My lord,
participate in the inquiry?
Yes, my lord, that's the point, my lord. Page
Yes,
number
my lord.
20.
That's why I called for the record. I received the record, my lord. I'll answer it before your lordship, my lord, and file my counter.
My lord, this is simply bogus inquiry, my lords. We have been telling the same thing, and right now the complainant herself has taken back the complaint, telling somebody has motivated me. This is nothing but an act of vengeance against the petitioner, my lords. Nothing more needs to be established, my lords. I seek a modification of the interim order, my lords. He needs to be reinstated, my lords.
What is the interim order?
Interim order is not
Not
to
to
fill up
fill up
that
the
particular post, my lord. Actually, his contract expired in the month of March 2023. Anyway, matter has to be finally adjudicated, my lord, and every year the contract will be extended. That will be the prerogative of the employer, subject to the orders of this honorable court.
The inquiry is not properly conducted doesn't mean that we have been acquitted of the charges. Totally.
There are 2 complaints,
My lords,
complainants
may
here,
kindly
my
have
lord.
page number 9 to
And now
18.
one complainant has come forward and saying that I have given a false complaint, I've been motivated or I've been pressurized. That is to be looked into, my lord. It's a sensitive issue, is my submission.
My lords, the basis itself has been flawed, my lords. The complaint itself is flawed, and now the inquiry is flawed. Both have been established, my lords. I seek a modification pending disposal of the writ petition, my lords. They may file a counter and
What is the modification that you're asking? That it
he
should
may be
taken back
reinstated, my lords, pending disposal of the writ petition.
No, I'm sorry. At the request of the London GP, the service is fine. To file a counter to the additional.
Yes, both my lord, yes.
Have been brought on record.
My lords may say it finally, my
After 2
lords.
weeks.
3 weeks, Your Lordship.
It's after 3 weeks.
Much obliged.
My lords may say it finally, my lords, because for the past.
Yes, sir.
We'll see it next time. Yes.
Services.
This is coming for production of records.
The records that they have produced.
All right. Yeah, got the report, Lord. I also asked them to be present in the court. They are also here.
What are the records that they have produced?
Sir, I explain, Lord. There's one index I have prepared. That one chart I prepared to the Lordships are verifying that, Lord, record verification.
All these documents are of 2022.
Period of 79 to 85, my lord.
Except for the first one, document. What is this 15/7/1988? It's the NMR.
Lord, that is what they have verified is list of NMRs working on daily wage basis. This is dated 15/7/1988 during the years 1983 to 86.
80?
86, 83 to 86.
83 to 86.
Yes. And after the court orders, Lord, they have explained the record. They have explained, you lordships may follow this. I'll tell you, Lord, and take your lordships to the.
So have you gone through this? Have you seen this?
No, ma'am. No copy is produced.
Give a copy of this. What is this record that you have given?
Office
Not all the documents, but this copy of this letter dated 15/7/88.
15/7.
Which you say that you have verified and then found that the petitioners are not.
No, I've only explained since last occasion the lordships directed me to produce the record. I have also specifically asked them what is the record they have verified. They have all the Lord. There's an executive engineer. He addressed a letter to the deputy executive engineer. Deputy executive engineer addressed three. There are 3 divisions. 3 divisions they have addressed letters. They have obtained replies from the divisions, and ultimately after their report, they have passed an order. My submission before lordships is if they have.
Have you filed a counter?
Yes, Lord.
Did you mention all this in the counter?
No.
Did you refer to all these documents in the counter?
Which documents, Lord? These documents.
These documents that now you have filed.
In the counter, last time when your lordships verified, when there was no clarity as to what has not been mentioned clearly, the lordships directed us to get the record. They said that they have verified the records and passed them.
So she had brought out that, you have stated under the Right to Information Act that there is no evidence, no records available.
No records available from, in the year 2011 itself, my lord, there are no records. But even then, they have implemented the earlier writ petition, my lord, which was filed by the similar place persons.
Of the letter dated 15/7/1988.
I'll verify, let them produce, let them give a copy, my lord.
The attendance details of NMR casual laborers from 1983 to 86.
We are from 79 to 85.
So 83 to 85 also is included here.
Yes.
I'll verify, my lord, from that.
Your names are not there. So you find a counter then, additional counter giving the details.
All the details.
Additional counter.
That she also has an opportunity of putting it to her client.
It's all that, Lord, is there is an order passed. In fact, Lord, if an order is passed, Lord, they ought to have contested the matter.
But see, you yourself, your officers, and when she asks her under the Right to Information Act, you give the information, no records are available.
No, it's not under, that is not furnished by us.
Yes, my lord. Your lordship may kindly see page 69. 69 of 2011 letter.
Page 69.
Yes, ma'am. In another similar place petition, my lord, 16455 2010. In that period only, they have asked for records.
Not to
9
them,
to
Lord.
2011.
Similarly placed
Similar,
after 23
but
years.
subsequently, my lord, subsequently in our case also they have sent that page, that is page number 60. In our case also they have verified
whether records are there or not. Page 60, my lord.
ఆనాటి రికార్డు చదవబట్టి కనీసం చూచి పరిశీలించడం కూడా వీల్లేని విధంగా ఉన్నదని.
In this, my writ petition is.
So from where did you get this list then?
Which page?
Page 60.
Page 60.
Page 60 in counter 323?
No, page 60 of my contempt.
I'll just clarify.
In that writ petition, your lordship make a Vishayamu 1, 2, 3, 4. Sixth line, writ petition 16986 of 2011, filed by Lazarus, that is petitioner hearing. 2011 also they are not having, and 2020 also they are not having, my lord. From there they have produced the.
What they are saying is that, Lord, these documents are, Lord, the records they have verified. Now they are stating that the records are not available.
And then how was they, what is the?
No, not that, Lord. Records have been damaged.
No, ఇక్కడ ఇచ్చింది ఏంటి? What is that information?
Lord,
ఇక్కడ UPC ఆనాటి రికార్డులు చెదలు పట్టి కనీసం చూచి పరిశీలించడం కూడా వీలు లేని విధంగా ఉన్నదని పలు పర్యాయాలు తెలియబట్టి ఉన్నాము. From where did you get these records then? That means either at that time you have no patience to look at the documents.
These persons are not there.
2020 we have the petitioner, sir.
Look at the office.
ఇందులో రికార్డ్స్ ఇట్లా ఉన్న చెదలు బట్టి పరిశీలించకపోతే లేని విధంగా అని చెప్తారు. ఎట్లా రికార్డ్ వస్తుంది?
DP, you should do this exercise in your office.
No, already I have done this, Lord. I specifically done. They have brought this record. I have verified this record.
Then why did they say like this and how can they get the record now? How did they get the record?
This, your lordship may kindly pass an order, Lord. What my only submission is that, Lord, after your lordship's orders, after 21 years, they filed a writ petition saying that some similarly situated persons have been granted the benefit. And that was considered, and Lord, now they have passed speaking orders.
Now
So,
you got from this record.
yes, Lord, this.
So that she gets an opportunity to go through it, whether there is any contempt committed at all.
Yeah, very.
Seen, printed.
Yes.
Yes. The learned GP has produced copy of several documents which have purposely gone into by the respondents before rejecting the case of the stationaries. One of the documents is list of cinemas working daily wage basis during the years 1983 to 1986. The letter is dated 15/7/1988. It has a list enclosed there for the workers for the daily wage cinema casual laborers working from 1983 to 86. The petitioners claim that they have worked from 1979 to 80.
79 to 85, some, my lord, some petitioners.
Therefore, the names of the petitioners, if they have worked, will have to. In spite of several requests, and even in the right to information act, it was always stated that the records are not available. Otherwise, the documents are now filed for export. So directs the respondents to file all the documents along with an affidavit, so that the petitioners can be given an opportunity to go through the same and submit. This document is an affidavit.
And my submission is that, my lord, it is a typed copy, it seems, my lord, it is not an original one.
So all that you can say after you look at it now.
Because original record, that is not a original one, my lord. They have to produce original record before this honorable court. Yes, my lord, they have to produce the original copy. Much of it.
You can go through it also. You see it and then return it.
Yes.
Latest
It's
report
up to-
after your lordship's Lord pointed out that aspect. we have also asked specifically a letter from the concerned persons. They said they have verified the record, which is not traceable, recent on 8/11/2023.
It's not traceable. But then how did they get this?
That is the record available in the office. That's a copy of record that is available in the office. My friend Millard filed a paper, said that Millard, the record is not traceable. On that point, Millard, your worships asked me, and I have written information I obtained, and also I asked them to Millard come be here for assisting the. 4 weeks.
Urgent motion list, my lord.
4 weeks.
Yes.
4 weeks.
Urgent motion list, my lord.
Daily list is coming at the top of the.
It won't reach my lord, your lordship. Urgent motion list, my.
Now we are taking care to see that no case is tipping
Much.
the list and every case will reach.
Much of.
Your case was somewhere, the రోజు వచ్చింది date by date వచ్చింది. Yes.
Earlier also it was posted in the urgent motion list, but that's why I'm asking for urgent motion list.
Appearance ఉంది కాబట్టి top లో వచ్చింది. Let it be under the same cabinet.
Millard, appearance.
Yes.
Appearance.
It is conditional.
Conditional, but in the list it is showing as appearance. We thought if it is not there, that is the reason why you got.
Because it's under the caption of appearance, it has come on the top of the list. Sorry, 4 weeks of the attend motion list of area on Friday.
Friday they are not ready, my lord. Only Thursday they are coming. GP is not available.
Wednesday will be ready.
Friday.
That appearance like
For appearance. Yes.
obliged. Original record may.
You have not produced any original record. You have to-
There is not those muster rolls, my lord, will be in the subdivisions. That's a voluminous, my lord, there will be registers, they will have to verify. All that they are saying that they have whatever
The list of all
the correspondence after the court orders stating that what they have verified. If your lordship, my lord, says that, my lord, still it is, the original record is required from the office, whatever the availability.
If this is the case, what is the direction of the court?
Declaration of the employee contract, by some
Just after, there is a council is not in. It's after 3 weeks. The letters. Yes. Who is appearing to the respondents? You are for? Bank of Baroda.
You are the petitioner for this post. The post.
What is the order in the challenge? Is it suspension order? And then dismissal also. Appeal dismissed. So you are not paid subsistence elements during suspension period. Paid? Huh? So one of your player was to pay subsistence elements. Achha, up to dismissal, they have treated you as under suspension, they have paid. So this prayer 5 is not necessary now. Not paying subsistence allowance to the petitioner since November 2016. So that will not clear. So now we are challenging the only the dismissal order or even the suspension order has to be.
Deference. Then the prisoner was in mental hospital 2 years and more. In the US, right. Produce and they say that
Why have you been dismissed from service? What is that? So let us go to the misconduct charged with it. Allegations. Page number. Page 38. Okay. 15 and 16. 59.
It's not when so details are
So we'll go, let me understand what are the charges against you.
to the employee officer that I have been attended by us to keep quiet. Otherwise, my mother I will not ask any question. Any question, any and this report I have given police program which constitute offense of Part 3. It's IPC
IPC ఉందా మన దగ్గర? Because this is a service matter bench, you don't have IPC.
My contention is encouraged was false where the office to do this whoever including person anyone who does something which is not which the problem are the means of providing commission was suspect. Comments to be mentioned. And sometimes six. Commissioners, who have commit the offense of self-dealing. Against the imprisonment of the it's been extended to 2 years. And for this and the section 1 is a non-constitutional law. Information has to not such cases. The information is given by the justice. Commission of the commission into the list of suspicion of the non. We shall enter not to be entered. The substance of the information in a book to be kept by the officer in such a form as the state government in this law in the this all the questions what happened who is good who is bad simply they are
So you have given a complaint to the police saying that they are intimidating you in from participating in the inquiry. And your allegation is that they have not taken any action. All right, noted. Noted. Now. Come to the charges against the petitioners.
now
120.
So that
First, let me come to the charges. I want to understand what are the charges against you, then how, whether your mental condition is in any way contributing to these things. So first come to the charges.
one line. 1 second. 1 second. To prove that I want from 6 to 27. But even now section 20. No government staff shall discriminate any person relating to the problem shall discriminate or reduce in that any employee who provides his and should not be ignored at any condition. It does. So that one is because so different so different all One is, if I start anybody up here, if I start anybody, only start this time, 30 cases. Over time, how many you have? Start. Another is, there are, start. All
So now the allegations against you are that you have misbehaved, threatening, violent. So you are saying you have done, if at all you have done, it's only because of your mental condition and not the otherwise. Okay. No, but the allegations are only of misbehavior. Misbehavior. So inquiry is for flawed because they did not permit you to even speak.
If I slap you,
Sir, we'll take it up on some other day leisurely then, because I think your case requires a lot of time. And we'll take some time.
if I slap you, the Olympics is not. They are doing exam. They are exam seated.
No, we'll take up some other day. Okay. Sir, this will require detailed hearing and a lot of time will be required. So not in the early hours, we'll take up at. I do not know the background of anybody here. Please. Nobody is trying to teach you anything, sir. Only thing is you can be little brief in your submissions. That would be appreciated. Okay, if you can limit your arguments. 4th December. 4th December. We'll take it up on that day at 2:30. Not 2:30, at 4 o'clock. At 4 o'clock. 4th December. Contempt not filed yet? You don't have the papers? You don't have the. What is that file that you have? Not this case. Give her the papers. At least another set. What is the date of the impugned order? What is the date of impugned order? Sir, why don't you answer when you are asked a question? What is the date of the impugned order? No order. Then since when? Since when are you not being permitted? Paragraph 4. Business premises. All right, for instructions, I'm posting it next week. Get in whether you have removed him survey from service. Since when are you working in this bank? 2010. So 13 years somebody works for you and then you don't ask them to stop immediately without any reason. Get instructions. At the request of the learned, standing counsel for the bank to get instructions in the matter. This next week. Yes.
Otherwise, services, section of charge. Before 220. Coming from.
At the request of the learned GP, file computer, the chapter, how much time?
3 weeks.
3 weeks.
And number 64, strict on minimum services.
Notice file? Yes.
First one is traditional bed. From there, on. There was two department. Then it got job, then other is pending patient, no charges can share that is minus. But then he is not, we are not able to. Can you see page number, the reply of the information, page number.
No, the reason why they are not giving you the provisional pension also is that the disciplinary proceedings are pending against you. So you got discharged from one and there is no. Drop. Huh.
Can you see page number 6?
Yes. Hmm.
Page number 6, senior payment. On one level, stating it somehow read and report verified on which they have the beginning. In this election, it is given to the state delegation where he has the board responded is certain. This was required by some of my chief ministers. Working at the current matters are not negotiated and the amount of fee is significantly for we have seen or related to IFC's list with the additional amount of 280. That's benefit given by the chief loss in the restriction that we are debating is somehow to still let it go from various states. Then we could pay that remaining amount. This itself later I have not received any amount. That is I also think as that for the from the apart from for the streets in that it is 2,500 months. For which the factor was government or or why we this to IT something. That is the pretty much. We know one level. I have seen the lines you before
No. Have they? No, you are saying that 3 cases were against you. Where one case discharged, the other case dropped. So you are speaking about the 3rd case. What is in the reply? You are speaking about the misuse and all that. That is when you got to the 3rd case. Only 2 cases. One is discharged, the other is dropped. Then why are we going into? Where is that order of discharge and dropping?
Let me see where my is Commissioner to permanent.
Huh? Page number 16 of your reply. I request the commissioner to kindly drop the charges framed against me. This is your request. So where is the acceptance by the commissioner? Where is the order of dropping the charges or discharging you from these charges? Huh?
Charges not fail. Just or not.
You are not prepared for the matter. Come prepared some other day. If you are not prepared for the case, don't argue. Take time. Don't waste court's time. It's on.
Come there also.
Yeah, for the respondent number 2. Yes. He wants time, 1 week's time. About now, what is this? Yes.
Central government interfered. State government. Of the side by trade. Specified the control shall be declared as the control followed by the Thirty-nine of the thereby director by which the he exercised also by all the state governments subject to the times of the government. Exercise power of the said powers are the state government does not be never close. But the attention of the election is rather of the civil market or a case as defined they do not expect to be. So the automatic schedule.
Oh, that is the main contention of the petitioner, is it right? What is your case? You are for the management of the company. No. You are appearing for R2, the employee.
Yes.
Okay.
Section 2 of LDI. It could be state constituted that then to file directly before the state court was state amendment of one of state amendment 1887 that we see the 61. As for the state amendment, the government are cited to directly propose their court and file their dispute.
Okay.
But same section of section 2 same section was amended by the central government, the central act, the year 2010. See, that is also the date 60. Same section was amended. So my submission is, once the central act is amended by the government of the state, so the state act is superseded by the central act. That's the for the that we have already cleared about. So there is a difference of procedure how to approach in declaration case. How to approach in 87 of date. There is a procedure directly to approach but in central government there is industrial tribunal, not that. See, it is not popularly known as industrial tribunal, central industrial tribunal. But if you see the nomenclature, they say that it is a central industrial tribunal from level. So both the presiding officer, that's the chairman of industrial tribunal, powerful presiding officer. So the central act came so then says that the workman has been terminated. First he has to go to consideration officer. Approach the consideration officer after 3 weeks. He is free to approach the level, approach the consideration. If no safety, he is free to approach directly to that. So the workman he has ignored the and directly on the state level, state level. Even if there is a of state and delegation was there,
even if delegation is there, central delegation says that whatever powers the central government exercising, the same thing be exercised in the state of. That means what? The central government can delegate the powers of central bank and central rules. But whereas the petition was filed in K4, that is AP state industrial rules. So my submission here have been pushing Parliament for last 1 year, we have filed state petition in September 2022, but still state was not. It's a very case and balance of evidence, name of the petition. Only thing is, he has to.
So the question of jurisdiction of the tribunal has to be decided. So what is the award?
When the award is not passed, when the proceedings are pending in the system, the level of law, they have. But since there is not the level of court is the proceeding and we were insistent to file many forms. And we have prepared many times to file petition to the level of court. And it was time, but now because they are asking this submission they say is necessary. That is central government also file their normal order some time.
Somebody has already filed a counter. It's response number 2 is filed. Yes.
And we also find that the government, what children have to follow, as the case of its sentiment of voter. On which petition disciplinary objection benefit people judicial aspect whether this or it must be a criminal adversity central government. Petition filed by the petitioner. The law find it at
So you yourself have filed a petition. IA is for what?
IA is for deciding what.
So the petitioner himself has filed an application for. But here the petitioner, applicant and petitioner are one and the same. So they have filed an application for deciding the preliminary objection. So what happened to this? All right, whatever page 7.
About the jurisdiction of this honorable court and also on the ground of proceeding by the asking. But these are the 2 points and then based on the objection. What do you want to answer? Find my problem which is followed at page number
74. Yes. All right, now. Written arguments by inspector. So has the tribunal decided? Has the
decided? Page 106. The other way should not be find at page 110. 110. The order starts from 106.
So they have upheld the jurisdiction. They said we have the jurisdiction.
Filed by the management and we discussed.
So this order is under challenge now.
My friend is trying to take some new the challenge is not so much state government has power.
So the preliminary objection taken by the management has been decided by the court level, which is under challenge before this court. Wait a second. Who is appearing for the central government? Huh? Saptaya. Her name is printed here. Were you represented before the lower court? No. You were not there. There are parties here. See, once, please. Once the issue of jurisdiction is an issue which has to be adjudicated, there has to be stay of all for the proceedings. The correctness of that order has to be decided by this court. Yes? So you have filed your.
In number 67 of my there also I have mentioned that section 2 already 2010.
So your objection has to be decided. All right. Let the respondents, the central government also file a counter. Let them say what is the jurisdiction. Yes, for number 3. Why Human Rights Commission has got a say here?
Actually, he has filed a petition. Then filed a petition for that. And in the 11th, then after that, then objection that multiple proceedings are going on, then he has gone to Human Rights Commission saying that
Humans now withdrawn, then what is your problem? Then, so why respond number 4 is necessary in this? So, docket or?
The report is proceeded in the inquiry, insisted to file based on the 90 days, written or plus Case is posted before the report for 20th November.
Old is here. Old is here. The final hearing వచ్చింది ఈరోజు అడ్మిషన్ క్యాప్షన్ ఎందుకు వచ్చింది రూల్ ఇసి వచ్చినప్పుడు already rule issue has been ordered. So let the respondent number 3 also file counter, then we'll take up the matter. At the request of the done. I am going to pass orders. Why are you? People have no patience at all. Wait for the court's order. Yes. When were you terminated from service? 2020. After 3 weeks, I'm saying that it should be listed. Let them file counter and it will take it up after 3 weeks.
And there are 66. Fine. Ravi Reddy.
Yes. So he's only seeking disposal of the representations for payment of salary during lockdown period.
Yes.
So what happened? What are you saying in the counter? Uh, I think in similar circumstances, the RTC, not, the government has issued a circular saying that everybody will be paid.
My lordship, the TSRTC has issued the circular clearly stating that to issue the salaries in month of July. But in month of July, zero, it was a clear zero. The salaries were not paid of June. I can also read the circular.
I think subsequently, when did you file this counter? You have filed a circular along with your.
Yes, yes. Page number, I don't have page number.
You have not filed it.
I have filed the circular, payslip and other. Page 12.
Well, So what? Suppose you were number 40. Yes. 45, GO 45. Hmm.
It was applicant,
See, your circular dated 6/7/2020 doesn't refer to any restrictions on payment of salary. Yes.
My lordship, in June, it was a peak pandemic and no one was allowed. There was a complete restriction on ongoing. Only district buses were running and no city buses were running.
many petitioners are there here?
10 petitioners.
Details of all the petitioners are here.
Yes.
This is not saying anything. You are only saying about the days of leave or present. For which month is it?
This leave in relation to full month. Last or March. For 15 days, 10 days leave. Not attended. That's 21 days. First, 10 days. So it's not attended.
My lordship.
Yes.
My lordship, I am clearly stating that all the other workmen who have been absent in July, they were also paid salaries, but not these 10 petitioners. Other members were also absent in the month of July.
Where have you said that?
In paragraph 4.
Please read.
It is submitted that now the respondent three unauthorized director salaries of petitioners without implementing circular from this affidavit. This one.
Private for para 4 is something else. Issued circular so and so with regard to payment of salaries. You are reading something else.
No. VP number.
All right. Shall we take it up in the afternoon? You will be ready?
Yes.
Continue. Item number? No, no, you should come prepared when the case is called, not, no.
Item number 68.
68, all right. Next is 67. Sheikh Karimullah. You want on 21st? All right, 21. 89. Huh? Next week. When you daily list entered and next week annappudu Monday list. Come prepared for the case. 67. I already, he also asked for it. 2111. Yes. Continuation.
Continuation be item number 66. Expired, nothing like.
Yes. Yes.
My lordship, the only purpose of the circular was to compensate the petitioners as they were not able to attend their duties. The respondent is defeating the purpose of the circular.
So with regard to April, May, their salaries were deferred and that they said separate instructions will be issued. For the month of June, you said you're going to make the payment in full. That is for the period they have worked.
Yes, sir.
That is what you are saying.
Counter affidavit also is sent by like. They were asked.
No, but what about her allegation that all others have been paid, but except the petitioner's case? Yes. There has to be some discipline, no?
Yes.
When you are called to the office, you have to go and work. If your clients don't go and work during the lockdown, then how are they supposed to get their wife to take it?
No, it was a peak pandemic. That time was a peak pandemic.
People were working.
No, ma'am. No, that
Up to May, the lockdown was there.
it was situated in the middle of the city, so it was red alert area.
All these people were living in the red alert area.
No, the depot was situated. They were unable to travel because they were living outside the district.
Outside the
Yes.
district where they're living. Have they said anything? And, that's
They have made many representations to the senior officials, but all of them were neither denied nor accepted.
presentations are still pending.
Yes. They have ignored.
And in the case of much somebody has directed that. whatever you are arguing now, that it is irregular, alert
Yes.
and all that.
Yes.
So you make a fresh representation, have directly representation. Yes.
HIGHCOURT matter. Item number 7. Tell us grievances.
He was not audible at all. He was not audible, so we couldn't hear what he said. So you want your daughter has right, you want the benefits, terminal benefits. Huh? So the benefits have been given to the. There is that representation. No, is there a claim by the second husband also? There is no claim.
As per the service records, Your Lordship, as per the service register, she has made her husband as well as a father as 50-50 equal share nominee, Your Lordships. On 21/8/2023, the writ petition which supposedly is given by the petitioner, she was hospitalized at that point of time. It was not submitted by her, it was submitted by a relative of her. And the father then made a claim, and in fact, the representation which is given, what is submitted to the State Election Commission contains witnesses' signatures, 2 witnesses' signature, Your Lordships. There are no names or addresses for them to verify. Now, as per the register, both of them are entitled, Your Lordships. And as on date, none of them have made any claim submitted in terms of the proforma or submitted the legal certificate or the other prescribed proforma in which they have to make the claim for the pension, the benefits, Your Lordships, till date. And if there is a dispute, once as per the register, there is a dispute, on 21/8/2023, the representation which is supposedly given, she was hospitalized, Your Lordship, and she passed away on 26th August. So we can't verify whether there is any validity to that representation or not. Once there's a dispute, they may have to approach the appropriate forum, that's the lower court, to get a declaration that they are the valid legal heir, Your Lordships. Because if the claim is again raised by the second husband, he may be entitled to in terms of the earlier nomination which is given. Yeah, 50 for the, yes, Your Lordship, but he has not made that pro forma claim. He can make that and he can take, I've verified with them just now. He has not even made that pro forma application. They have to submit the GPF account and all other legal certificates also to get the benefit. She passed away in August, 26th August, Your Lordships. They have still not made any this year. I will file a counter, otherwise this may require a counter, Your Lordships. Then I'll I'll get all the documents, whatever is available in our records.
Request on the standing council. Next year.
P. Sudhir Rao, Your Lordships.
Yes, that's. So you have already argued your matter that the GP has got the time yesterday. During his lifetime, he was not dismissed. You cannot dismiss a person who is no longer.
Submission, look into the prayer, Your Lordship. Prayer, Your Lordship, repetition prayer. Was only seeking dispose of representation, Lordship. Subsequent to this representation, we pass the speaking order, Your Lordship.
What is the prayer? Please
First,
read.
may is therefore pray this honorable court may please to issue it order or direction more particularly one in the nature of writ of mandamus, declaring the actions of the respondent number 2 not considering representations dated 19/6/2017 and dated 25/7/2017 of the petitioner seeking the retirement benefits, PF, gratuity, pension benefits, other
This is offense as arbitrary, illegal, unjust, and a violation of Article 21 Constitution of India, guaranteed under our Constitution, and consequently direct respondent number to consider the representation dated 19/6/2017 and 25/7/2017. Your Lordship. Subsequent to this, Your Lordship, representation is possibly the speaking out of page 25, Your Lordship. In 2018,
That has not been, prayer has not been amended.
for my knowledge, it was not amended, Your Lordship. Even we filed counter with.
Your representations have been disposed of, rejected. Then you have to challenge that.
The same model which is what is page 27.
No, your representations are dated 19/6/2017 and 25/7. This is passed on 12/7,
2018.
but you have not challenged this order.
She would have amended the prayer.
They have simply stated.
This was the representation.
Even she is aware of Your Lordship. Writ affidavit also, she stated that, Your Lordship, that the speaking order has been passed, Your Lordship. Yes, this order has been passed, Your Lordship. Para 9, Your Lordship.
She has enclosed it along with the referential.
Yes, Lordship.
You said after filing, we have disposed of, so I was wondering how it has come into the writ papers. This is prior to the filing of the referential itself. You have passed an order dated 12/7/2018.
Yes, Lordship.
Here you are saying that you are not entitled to any benefits.
Lordship, last Your Lordship, last.
This is the
Order,
order.
the government memo on the reference. As it was dismissal order, Your Lordship, they are not entitled, Your Lordship. Dismissal employee, Your Lordship.
How can
Whether
they
it is,
dismiss a person?
Your Lordship, that is the, Your Lordship, that has to be put into when it is challenged, Your Lordship. Because it is, it has to be gone into the when it is challenged.
Dismissal order. She said,
Because
"No,
dismissal, once
dismissal order be there. Problem.
once employee is dismissed, Your Lordship, is not, the legal aids are not entitled for any benefits, Your Lordship.
Any benefits?
Any benefits, Your Lordship.
If you are dismissed, removed, you are entitled to, but dismissed, you are not entitled to any benefits. So you have to challenge it, no? You don't want to challenge it. Why?
No such grounds has been raised in the affidavit or in prayer portion, Your Lordship.
The legal ground can be raised at any stage. May not be said in the affidavit. It's a legal point, isn't it?
But it should be in consonance with the prayer and the affidavit, Your Lordship. Our needs, Your Lordship.
Prayer
Nothing has
is
been
for
checked.
the representations, her prayer is for payment of the benefits.
We have passed, Your Lordship, dismissed order on basing of the conviction, Your Lordship. Now, the judgment cited by my learned friend, Your Lordship.
But
So
no,
that
you must follow the rule. You know that she has died? Are you aware of the fact that the petitioner has died or not?
when she filed,
So how can you pass an order?
when the petitioner approached the legal services authority, Your Lordship, then we came to know that he is died, Your
He
Lordship.
has made a representation on 19/6/2017, 25/7/2017 for death benefits. Then how can you not know that the person is no longer alive?
Because, Your Lordship,
How can you pass an order?
We-
You have to follow the rule. What is the rule according to?
Your Lordship, we relied on the conviction, Your Lordship.
No, no.
Conviction proceedings, Your Lordship.
Okay, fine. What is the rule according to you? You are the government, isn't it? You tell me the rule. If a person dies, while disciplinary proceedings are going on, what is the rule?
It will abate, Your Lordship, but
Huh?
abates, but the proceeding says,
passed this order?
Proceedings shows that your lordship, the
Who is the officer who has passed the order? Commissioner. A person in the rank of commissioner doesn't know the rules. He doesn't know the rules. Where is that order of the board?
lordship may direct the
Uh,
lordship may
you should know.
lordship may direct the
He is the
petitioner to
secretary.
lordship may direct the petitioner to withdraw and challenge this proceedings, your lordship.
Right?
Because lordship, now your lordship, these proceedings has to be challenged.
They get abated, so this order becomes non-est. Lay of law.
No such plea has been taken in the affidavit and your lordship.
For an invalid order, you do not raise a plea.
Because your lordship, he was convicted in 91, your lordship. Some of orders were not passed, your lordship. Even inquiry has been completed, and inquiry report has been submitted, your lordship. But disciplinary authority has not passed any order, your lordship. But subsequently, as per their government, your lordship, he was supposed to retire in 2001. Subsequently, he died in 2013. When they approached legal services authority, the file has been forwarded to the government and the instructions of the government, this proceedings has been issued, your lordship, 2018. Stating that on the ground of conviction, your lordship, not on the disciplinary proceedings, your lordship. Only on the ground of conviction, these orders have been passed, your lordship. As the offences are of grave nature, your lordship, they were considered and convicted.
Yes, all the case. How many years? 60. 60 years.
And the corporation has connected the legal without actually validating the condition of the because of the institution. And it and God itself checked it. There's
Remember? 20. Yes. It's suffering with this problems. It will 5 years and probably he needs complete bed rest and physiotherapy. Okay.
And you got the patient the diagnostic of the legal which clearly shows the deformed cat qualify itself. Where the normal diamond is to 50.5 is diagnosed 50.8. And the federation of the waiting means right. Right broad based is the federation identify is level positive by right of the
Okay, then. When did he ask for the pre-medical examination? Why so late? He's suffering from the problem since 21. So why did he wait for all this time? That his medical certificate is stated what?
Medical certificate
14/8/23.
Yes, ma'am.
Yes, who's appearing for the respondents?
Sorry. Yeah, sorry.
Yes, come. Yes.
File number 70, today, for services.
Okay, please, Your Lordship.
Yes.
For last occasion, Lordships have heard me, my Lord, back on 19th September 23. But this is a case where, my Lord, the petitioner is suspended at page 123. Lordships wanted to have a look at the reference in that suspension order because my
Challenging the suspension order.
at page 123, Lord Speaker,
What are you challenging here?
suspension order.
Suspension.
Kindly see page 123, my Lord. Some FAC person comes and suspends me on the allegations, my Lord, 8 of them, which were already considered and dropped. On the very same allegations, you Lords have seen, my Lord, this 123, 1, 2, 3, 4, 5, 6, 7, 8 issues raised by some other complainant brought against me were considered by very superintendent engineer asked for a report. My Lord, at page 50, my Lord, is the superintendent engineer asking for the report from and a preliminary inquiry against this and asking the executive engineer to conduct a preliminary inquiry. Page 50 on 21/6/2022. Report was submitted at page 52, my Lord, by the executive engineer saying
You
that
are placed under suspension on 1923.
correct, my Lord. Before that, all are dropped. My case is that page 52 is the report where, my Lord, very same issues are considered and then dropped. Report is given in my favor. Thereafter, no action, no charge sheet, nothing. Suddenly, same things are issued by the in charge superintendent engineer.
So,
And then,
but 1 minute, sir, 1 minute. Page 123 is in respect of one Mr. P. Shankar Verma.
correct, my Lord.
Page 52 is in respect of one Syed Abdul Hanan.
Syed Abdul, I have given a notice to, there was a notice against him. Then, Lord, he has given an explanation. In that explanation, he has raised all the issues against me. So they were all considered, Lord, at page, for example, if your Lordship goes to page 53, page 53, my Lord.
Yes.
Page 53, memo government of Shankar Verma, superintendent and managed to issue through the executive engineer assembly. So all the issues that were raised by Syed against me, Syed Abdul raised against me, were considered and found to be untenable.
Yes.
But when Syed Abdul was given some notice, explanation, instead of answering, my Lord, he was throwing everything, my Lord, on unconnected issues are said against me. All those were directed to be considered and a report be submitted. That is the direction by the superintendent engineer, my Lord, by, superintendent engineer at page 50. And in response to that, my Lord, executive engineer conducted inquiry. And then page 52, my Lord, he has given remarks saying that everything is false.
Okay.
False. Very same issues. I don't want trouble, your Lordships. Last time, your Lordships were pleased to see very same issues were considered. And after, my Lord, I was transferred after that. I was transferred also. After the report was directed to be submitted by the executive engineer, even before report is submitted, I was transferred. On 16/7/2022, report is submitted, my Lord, finding nothing against me on 14/11/2022, that is page 52. Then, my Lord, I was suspended on 19/2/2023 on the very same issues. When I argued this before Lordships, you Lordships have gone to 123. And then notice that there is a proceedings dated 31/8/2023 by the chief engineer.
Yes.
So, your Lordships wanted to see whether there is anything new in that. That's how, my Lord, Lords have directed the respondents to get that memo. That was in September, my Lord, since then.
Yes, a copy of the same is now given here.
Sorry, my Lord.
Copy of that memo is now furnished before this court.
Yes, Lord. If there is anything new, the Lordships wanted to see, maybe those things are all dropped. But if there is anything new,
Superintendent engineer has given that to suspend pending inquiry by framing article of charges against P. Shankar Verma.
on the very same issues.
For his complaining against his superior directly to the Commissioner of Police, Hyderabad City, Command Control Center, Banjaranagar, Hyderabad, in the reference second side. Without addressing to the higher authority, higher officer initially as a result. This clearly shows gross negligence towards higher officials. Spoiling the name of the Department of Public Land.
They don't say that they are wrong.
Oh, no, this is with regard to something else.
No, my lord, that complaint.
Also harassed Kumari Aishwarya, Arshia.
That is already cleared. That's all.
Previously calling her to the officer at order, no other staff are present.
My lord, that has been considered by considering that, my lord, they have specifically said, lots are referring to which one, my lord, in page 123?
No, not
Four.
in page number 123.
Yes, my lord.
You see, this is
123,
a
I
reference. Yeah, page in the 123, there is a reference to
4.
Chief Engineer's memo dated 31/8/23.
Correct.
Better look at the copy and then submit. Is furnished a copy. Here it seems you have complained against your superior officer directly and therefore that they try to take action.
My lord, for example, Ayesha, I'll come to the complaints to the superior officers. Ayesha, in Outspeak NEC 123, my lord, item number 4, it is alleged that same thing what is mentioned in 31(8) is also reflected at item number 4, para 4.
Yes.
For Ayesha. My lord, that will automatically come back to page 54.
Now, what about your complaining to the higher officials about your superior officer? There seems to be something about that.
My lord, that is one.
That is number 1. Has complained against his superior directly to the Commissioner of Police.
My lord, I'll just, 1 second. My lord, I'll just go to that, but kindly have a look at.
Item number 1 in the order 123.
Yes, Lord.
Item number 1.
Yes.
So this could not have been part of the inquiry earlier.
No, that is what I'm saying, my lord. The only thing is I'm a whistleblower. I was writing to letter the higher authorities. It's not as if they're all false. They say the image is wrong. That means being a subordinate officer.
Whether it's correct or not, that somebody has to verify and submit. We do not know. I don't know whether any inquiry has been conducted on that.
Exactly. My lord, if it is found that my lord, kindly see, my lord, page for 74, I gave complaints to various authorities about the illegalities and the corruption going on in the office. And in retaliation, my lord, the higher officials, the department has so many problems, and my lord, nothing is being clarified. Therefore, my lord, I went to higher authorities. I'm a whistleblower. It is not their case, my lord, for a minute that these are all complaints found to be false. My lord, kindly see page, they're all pending. Investigation is going on. It is a retaliation so that, my lord, arm twisting tactics so that I can take it back. For a minute, if lordship takes page 59.
Team of 25/9. Why you have not filed count of him now?
Last edition directed me, Lordship, to produce that proceedings, Lordship. I produced the matter, it is not reached in Lordship signature.
19/9 it has come again.
Lord, may I just draw your lordship's kind attention to page 54 for a minute, Lord.
Page 54.
Yes.
Yes. Yes.
At page second block, my lord, abusing of female staff, Ayesha and all that. Kumar Ayesha.
Yes.
The answer given is on the right side. The statement submitted by Sri so-and-so is completely false. He raised certain issues. They were found to be incorrect. There is no complaint from Ayesha. He somehow wanted to escape that Syed Abdul Hannah. And then, and kindly see, next is let out watchman accommodation. That is item number 5 in page 153, 123. All of them are found to be false.
Yes.
My lord, at page 6, next page, 55.
Yes.
6. Page 55, 6, misappropriation. False. This is my lord, para 6 in that 123 suspension order. Demanding money, 8. False. Filing the cases under so-and-so against department before Information Commissioner, TS Information Commission. This statement was not mentioned in the explanation letter. There is the explanation by Syed. This shows his bad and false intention and misguiding the higher officials, which is very bad on his part. After saying that further, it is informed that submitting two different letters from one memo, that is Sayer, towards his explanation show his bad and false intention and misguiding.
File a counter, but see, on the very same allegations where your own inquiry officer has found the allegations to be false, how can you place a petitioner
Inquiry
for?
conducted in respect of other person, my lordship.
No, but there, all these allegations against him are found to be false. So you have to consider that. How can you take that into consideration for suspending the petitioner?
Kindly see page 123, my lord, it's so vague. Page 1, item 8 is other civil allegations of misconduct. So vague. And I was transferred already from that post. When the lordship knows for once I am transferred, if they want to conduct, they can conduct. I am not even coming. Page 51 is my transfer. When the superintendent engineer asked the executive engineer to make inquiries, even from preliminary inquiry, my lord, I was not allowed to be there. I was transferred at page 51. After 1 year, 2 months, after everything is dropped on 14/11/2022 at page 52, because I gave complaints to superior officers, they say it is nothing but arm twisting tactics, allowing the fraud to go on in the department.
All right, yes, yes, sir. Internet Chief Steward has furnished a copy of the memo dated 31/8/2020, which apparently formed
Item number 7. Item number 7.
My lordship, it is coming.
Yes.
It is coming up for counter, my lordship, 2 weeks may be granted for shoot answer.
Oh, which is the department here and my husband. No, already there was a direction for you to get instructions as to whether the budget has been released for payment of pension to the petitioners herein as per letter dated 15/12/2022, addressed by the Director of Veterinary and Animal Husbandry to the Special Chief Secretary of the Government. What happened? 7/8/23 is the direction. You haven't, there is this letter dated 15/12/2022. Page 15. And budget estimates, there is no budget available under the head account on so the financial year 22/23. In view of the above, it is requested kindly to release additional budget for the financial filter under the head of Contempt to enable to pay PRC 2020 arrears to the retired redeployed employees who worked in the office. There's only one person. Make the payment. What do you expect?
Next week, instruction.
This matter came up almost 3 months back. And you haven't obtained any instructions still now.
Starting to say that the national event later also not address it the same.
Then
1 week maybe. Fine.
1 week, come up with some, so that you know you're going to pay the pension. How is a person survive? If we don't get salary for 1 or 2 months, we will know. Huh? They are also paying. Face the problem. Face the problem. And the request of in adjourned motions. Is there going to be no end to this?
This is at the instance of the government, your lordships, in the previous order, which was amended by your lordships, the relief portion. Lordships directed the segregation of class 5. The difficulty your lordships the government faces is that these posts are not class wise. So there is no post exclusively for class 5. There can't be a segregation for that class 5 alone. The dispute was with regard to the BPD and DPD candidates. Your lordships has rendered a judgment, nobody is in appeal. The judgment attained a finality, but in the last portion, your lordships directed to segregate class 5.
DPED are eligible for classes 6 to 8.
Yes.
And also 9 and 10.
9 and 10.
And DPED are holders for class 5 and also classes
Yes.
6 to 8.
6 to 8. But the last portion, your lordships, last 2 lines, your lordships directed, it is made clear that the official respondent shall segregate the posts of PET teachers for class 5 and consider only the DPED holders for such posts. The post is not class wise. For one school, there is one post. There is no mention of any class with regard to that post. Therefore, your lordship, there cannot be a segregation for.
There are no, don't do it then, that's it.
No, the classes are up to 9th and 10th. The post is 1. There is no possibility to say that this post is exclusively for class 5. That is the only post available.
That's why you are not able to segregate.
The direction you lodged.
Classes 6 to 8 you are able to segregate.
That was the earlier direction in the division bench. It was undertaken. That was upheld. That was considered before the court that it will be segregated. There is no difficulty. What my learned friend Rahul Reddy on the last occasion representing the DPD candidates said is, NCT regulations pertain only from 6th to 8th. So who will teach? Class 5 was in that context your lordships made this observation. But the difficulty now is the government can't segregate that one particular class 5 post.
The notification you have given for classes 5 to 10 or only for classes 6 to 10? 5 to 8. 5 to 8.
That has. That was the conundrum, your lordships. What has happened in pursuance to the notification?
Be able to segregate. How did you work out the vacancies?
In the earlier round of litigation, that was the core issue, that without segregation, the posts ought not to have been segregated. But in order to save the notification and the posts which were applied, and a lot of candidates were successful, dispute was with the BPD and DPD candidates. So the intention of the court and the government, and in the second round also, was not to set aside the notification on that ground. but a method was worked out to segregate the classes, that is 9th, 10th and classes from 6th to 8th. Your Lordship said, pursuant to the NCT regulations, that the BPED candidates are fit to teach from 6th to 10th. And only 5th class, when we again came back to your Lordship saying that it requires a minor correction in as much as 5th class, that 6th class was there. My learned friend said 5th will remain. But in these circumstances, your Lordships we are before your Lordships so that there can be an end and then the appointments can go on.
Tell me how you are going to segregate for class 5. When you have issued the notification, have you said that classes 5 to 10?
It was 5 to 8 only.
Now, 5th class only DPED candidates can teach. Then you have to segregate. Find a method yourself. How can
I had some rounds of discussion because for compliance of your Lordship's order, it was I'll get back to your Lordships. May kindly take up next week. Is there any method to?
You have given a notification for classes 5 to 10. And this court has already observed that for classes 6 to 8, BPED holders are also eligible. And 9, 10, only BPED, only class 5 was left out. You have to segregate. How you will do it is your headache.
Because in the earlier round of litigation up to the division bench, a concession was made saying that these posts will be segregated. But there this issue of 5th was not there. Now your Lordship, since it has come up, I'll put it to them, we will sort it out. Your Lordship may take it up next week. Is there any way to?
You'll have to find a way. How you will do it is.
Next week, your Lordship.
By next week, I'll put it up.
I was not aware of filing of the contempt because we filed this application much prior to the filing of the contempt. Contempt, your Lordship, since the facts are before your Lordships, what comes in our way is brought to the notice of this court. Yes.
Along with the contempt.
BPM.
Item 74, my lord, I beg to appear. I'm sorry, my lord. I am unable to be physically present.
Yes.
My lord, the petitioners, my lord, are retired employees. My lord, as AAOs. My lord, the amounts are sought to be recovered on, my lord, holding that there is some erroneous fixation of pay scale. My lord, after a lapse of more than, my lord, 15 years. But straightly covered by judgment of divisional bench of the Honorable Court, where it relying upon the Supreme Court judgment, said that after 5 years, not more than 5 years, if they have provided any benefit, they cannot recover with regard to the amounts. My lord should see the.
Where is the judgment? Copy of the judgment?
Yes, my lord. My friend has got a copy, my lord. He will furnish me a copy.
Yes. Alternate file? Yes. What are they saying in the counter?
Counter, same thing what they said, they don't dispute. They say that erroneously it was fixed and we have been given that benefit erroneously in the counter. My lord, to see the counter, my lord. 96 they have given the benefits. Stepped up with along with the person who was junior to us erroneously. For one petitioner 96, other petitioner 2001.
So here also, is it the case of you not passing the departmental test and then report?
Not departmental test, my lord, it's step up pay, my lord. It's like this. If a junior
Step
is
up of pay.
stepping up of the pay.
It was erroneously stepped up.
Yes, in my lord, in any matter, where my lord, they are supposed to recover the amounts on erroneous fixation of pay scale or stepping up of the pay. My lord, beyond 5 years, they cannot do it. That is the theme of the
With appearing for the respondents? Huh? Mr. R. Vinod Reddy. Where is he? Yes. Come. Next.
Item number 7576. Termination against
75 and 76. That's 26. Women reservation. It's a covered matter. What is the problem? Supreme Court judgment, Rajesh Kumar Daria, you have to follow the horizontally.
You already explained how judgment fails all rules.
These are for which post? Page 30 is the notification. So which resolution have you given me? Page? Yes. No, Hyderabad, South, Hyderabad Central. Table. South,
Hyderabad Central, Skada. It's the vice of this.
Okay. BCA, there's only one in Banjara Hills and one in Secretariat. And SCADA one. That's all. Only 3 posts are there. Where is that one? EWS, BCA, BCT.
Only 2 posts will come to us. But they wanted 60,000 people. But there are only 2 posts. 1% only. Even we need to
One must have come in the open category.
that is the difference. Because it's very hard. But women must be targeted. The woman
against the woman. Only whereas there is any transform, and a woman can account. Rajesh Kumar Arya,
Yes.
Number 87. Marks out 35. There are the marks are positive marks, directly converts. Already, candidate for already applied on the
Where are the marks of the petitioner? Where did you mention about petitioner's marks? That's right. Mark 43, rank 170. 117. Whereas Mark 36, rank is 782. So the first three candidates are above you, both in rank wise as well as marks wise. 4 and 5. Both, why not 4? 4 also is less meritorious than you. Why you have no objection to the 4?
I would get a chance.
No, you are saying Salva Namrata, fourth ranker, she was selected under 5% quota, but has not joined the post.
Person, 5% bonus, has not the right. One place for
Yes. Yes. Yes.
For examining from the There are two types of play. This will be
Social reservation as contrasted from social reservation under Article 16. It is an overall. In case it is an overall personal reservation. Yes.
And then I have candidates and then if that's not sense is equal or more than enough. So that's why they can interest faster. Start this in Yes, it was. Instead of being or that some
Say 483. The relevant para is para 9, 10, 12, 15, 17 and 18. Para 4 also you lost my kindly see. My learned friend appeared in that case on behalf of the Honorable High Court. Same plea was taken. Our rules permit horizontal reservation as if vertical reservation, but that was repelled by the Honorable Division Bench. Para 4 will also at page 71.
There is about the horizontal reservation, how it should be and all that. There is no senior counsel says these judgments are not applicable to them.
That contention in the judgment, that contention was negative. For that reason only, I want to show the relevant rule which was considered by the Honorable Division Bench. Para 4 Milaj. Para materia with the rules Milaj. At page 71 Milaj. Rule 10 of Andhra Pradesh State Judicial Service Rules, henceforth called as special rules, has provided reservation of appointment. Since it will have a bearing upon the controversy to be resolved herein, we prefer to extract herein below. Rule 10, reservation of appointment. The rule of special representation, namely Rule 22 In Andhra Pradesh, state and subordinate service rules, insofar as it relates to the scheduled caste, scheduled tribes, shall apply separately to the appointments to be made by direct recruitment and recruitment by transfer to the categories of judicial magistrates of the second class and junior civil judges, and the reservation of appointments to these categories insofar as it relates to backward classes shall be for the appointment to be made by direct recruitment only. The words part 2 omitted. The provisions relating to reservations made for appointment of women.
That that judgment will not apply. On its, where the court has said that it is applicable.
Para 12, entrance argument is there.
When has it dealt with this?
Para 17, my lord. Para 17, my entrance argument was there. Referred to. Para, your lords may kindly see para 12 for first for a moment, and then para 17 it will be useful.
Yes.
Para 12. Para 11, rule 22A was also extracted, human reservation in appointments. This rule and the rule which my learned friend is referring to in this case also parameteria. Para 12 below. We therefore have no hesitation to hold that General Rule 22, 22F Special Rule 10 are only intended to advance the cause of women by ensuring 33 1/3 percentage of vacancies in each category such as OC, SC, ST and BC are filled in by such women candidates. Such reservation of 33 1/3% in favor of women is a horizontal reservation, but not a vertical reservation. If we were to construe it otherwise as a vertical reservation, the total percentage of reservations would touch 79 1/3%. Thus, at that time 79 1/3% belonged. Now 4% BC reservation was also added. It amounts to 83 1/3%. If 6% under 4% was added recently with regard to ST candidates, if that is also added, 78, 83 plus 4, 87%. Thus, reducing the open competition vacancies to a mere 20 2/3 percentage, which is wholly impermissible. It will then fall out of the crystallized ceiling limit of 50%. Therefore, to save the reservation of posts or vacancies in favor of women from such a catastrophe, they are liable to be treated only as horizontal reservation. In other words, in each of the segments is open competition, scheduled caste, scheduled tribe, backward classes, the states will ensure that 33 1/3 percentage of vacancies are filled in by women. If the normal course of finalizing the merit list, such number of women candidates representing 33 1/3% make the grade on their own, no further action is needed to be undertaken by the state. But on the other hand, if there is any shortfall of women candidates, to the extent of such shortfall, from the bottom of the list, the meritorious male candidates would be replaced in the reverse order by next most meritorious women candidates in their descending order of merit. By following that Rajesh. Yes, Lordship. Next para 17, your Lordship may kindly see. In fact, the contention canvassed by.
This one short. Let's hear him as to how this is not applicable.
This para 17, your Lordship may notice, and then your Lordship may hear and friend senior comes. In fact, contention canvassed by Sri G. Vidyasagar that the rule Rajesh Kumar Daria and Shiv Prasad is worded differently than in the instant case does not make any difference. In principle, the important question is
whether the reservation of posts or vacancies in favor of women should ever be treated at par with the reservation provided for by the state in terms of clause 4 of Article 15 and 16, or should they be construed as special provisions in terms of clause 3 of Article 15. That principle has now been well settled by the Supreme Court in Anil Kumar Gupta case as noticed in Supra. Hence, it ascribed constitutional sanction. The Supreme Court laid down the principle of treating reservation in favor of women candidates as a horizontal reservation, but not as a vertical reservation. We are bound by this principle of jurisprudence. Therefore, we are unable to subscribe to the view canvassed by Sri G. Vidyasagar appearing for the second respondent, as the rules in the above said cases merely made explicitly clear what is otherwise implicit. So, Lordship, by any stretch of imagination, women reservation cannot be treated as vertical reservation. That if that is treated as that, then it exceeds 50% ceiling limit and it violates in the Sahani case. That is my submission.
Yes. You have filed a complaint? What are you saying in the complaint?
You are not for moments in the rules which are governing the court. That is at page 147.
Have you challenged the rules?
Rules were not challenged, Milashko, but one more aspect, my land senior continues, Milashko. One more aspect on rules with regard to rules, Milashko, I filed APSCB service regulations rule 22 and 22A at page 127 to 135. Your Lords may kindly see.
Yes.
127, your Lords may kindly see. APSCB service regulations. Rule 22.
Yes.
Reservation of appointments by direct recruitment, by promotion and recruitment by transfer. Where special regulations lay down, this is general rule, Lords. Next page, Lords. Rule 22A. This is with regard to women reservation. Lords may kindly see. In the matter of direct recruitment to posts which women are better suited than men, preference will be given to women, provided that percentage given to women shall not result in total exclusion of men in any category of post. Next one is important. In the matter of direct recruitment to post for which men and women are equally suited, other things being equal, preference shall be given to women and they shall be selected to the extent of at least 30%. Later is amended as 33.1% of the post in each category of OC, BC, SC and ST quota. Their rules contemplate only preference. It is not in dispute that for these posts, both men and women are equally suited. Then only preference has to be given. Now they are applying general rule 22, which provides for reservation. The 126 page 126 they are relying on this rule 22 of AP state and subordinate service codes.
22 also provides what? Where special regulations set down?
But their special regulation provides only preference to the women. If woman candidate and male candidate get equal marks, then woman has to be given preference. Other things being equal is the word used, but they are not treating that as by following that special rule relating to women. By following general rule, they are providing 31% reservation, not preference. That is also arbitrary. My learned friend states we are following rule 22 of general rules, AP state and subordinate service rules. As per that, we are providing reservation, women reservation also as if vertical reservation. Only to that extent, my lordship, I want to bring to your lord. That rule 22 relevant part after amendment is at page 126. Amendment, my lordship. In the matter of directorate posts for which women and men are equally suited, there shall be reservation to women horizontally to an extent of 33.13% of the posts in each category of open competition, backward classes, so and so, and meritorious posts and quota. This rule is not directly applicable, my lordship. They have to adopt this rule and they have to amend their rule 22, regulation 22A. That was not done by them. Based on this, they are providing reservation. When their regulation specifically provides preference, they are following this and providing reservation to the women. On that context also, it is bad. 22A, my lordship.
50% of the post in each category, horizontally, it's not the horizontal reservation.
22A, one speaks of only when women are more suited, they have to be filled up.
Horizontal reservation only.
Even as per amended rule also, it has to be applied horizontally. Then they have no case. One thing is, as per their regulation, only preference has to be given. 22A2. Even otherwise applying amended rule 22 of AP state and subordinate service rules, then also they have to apply women reservation and horizontal reservation only.
Either way, it has to be horizontal.
Yes, my lord.
Let them explain how your Are you following the horizontal reservation or what?
No.
Huh? No, you're not following horizontal. Why?
That's what happened. Well, my friend has made the judgment of the Supreme Court without referring to the rule which is applicable. Merely because there is a judgment of the Supreme Court, it does not mean that every rule will be.
What does the Constitution provide?
Constitutional provision means reservation. There is no reference to whether what should be horizontal or what should be vertical.
But rules are amended saying that it has to be
My
horizontal.
friend has got confused. That rule is amended after the bifurcation of the state by the Andhra, not by me, pointed by the Telangana state. Page 125.
And the Telangana state has not amended prior to amendment. What was the rule?
Yes, that my friend did not explain. Therefore,
You please explain. What was the rule prior to?
Rule is there is no reference to the horizontal reservations. The rule which I was following is at page 129. Page 127, rule 22.
Yes, sir.
TSHC service regulation. Rule 22. At page 127.
Yes.
Reservation of appointment by direct recruitment, by promotion and recruitment by transfer. Where special regulations lay down the principle of reservation of appointment shall apply to the appointment by direct recruitment to any service, class or category, or by promotion from a lower category to same service, or by transfer from another service. Such appointment shall be made on the basis of regulations for reservation of appointment by direct recruitment or by promotion, end of or
transfer made by the state government in respect of their own services. So I follow the state government. Now the state government too. I mean, it's very large attention to the state government too, Rule 24. Page 144. Telangana State Subordinate Service, my friend advisor. I don't know why he's. Rule 22 is at page 136. Reservations may be made for appointment to a service class or category in favor of scheduled caste, scheduled tribes, socially and educationally backward classes, women, persons with disability.
Where are you reading?
Page 136.
Yes.
Rule 22. Reservations may be made for appointment to a service class so and so and so. Women, as may be prescribed by the government from time to time, to the extent and in the manner specified hereinafter in these rules or as the case may be in special rules. The principle of reservation as hereinafter provided shall apply to all appointments to a service class or category by direct recruitment, otherwise by direct the principle of reservation is also the two unit of appointment should provide. Then I will skip over to them. Then I go over to next minute. Clause 3 at page 138. Provided that the claims of members of the scheduled caste, scheduled tribes, socially and educationally backward classes, women, and the persons with disabilities or rights service, as the case may be, shall also be considered for remaining appointments, which shall be filled on the basis of open competition. The number of appointments reserved in that category shall in no way be affected during the period the reservation of that category is in force. So I take the women reservation and others should be considered on the basis of the merit and open competition.
Can you please explain this rule again to me?
Provided that the claims of members of the women shall also be considered for the remaining appointments, which shall be filled on the basis of open competition. The number of appointments reserved in that category, that is women, shall in no way affect during the period the reservation for that category is in force. So what I do is women reserve vacancies, I consider women. In the other, I will consider women and the men on the basis of the open competition. That is my rule. Then I have also specified what is the roster point. In a unit of 100 vacancies, this is the roster I am required to follow.
So
If the
what
roster
you're saying is, women will be considered in the open competition, but also the reservations in the category will also be maintained.
For them will be maintained.
So if
That is
more
my-
women are selected.
They may be
Selected.
open competition.
So what you are
Whether
saying
that-
is, for example, 5 posts are there. So you will keep the 5 with women and also fill up the others also if women candidates are open.
They come into merit.
Merits.
That is
If
the rule.
7 candidates are there.
That is the rule.
So you will keep the 2 as open and the 5 in open category, let us say only 3 women have stopped. There are 5 reserved for women. So you will again fill up the 5 with 2 women.
Women, if there are
Irrespective.
That is the rule.
So already there are.
This rule is not under threat. And now I draw your lordship's attention to the judgment my friend is relying upon as that is the law. That is Rajas.
What does the constitution say?
Rajas Daniel.
Yes.
Because they sheet anchor in the judgment of the Supreme Court. That is Rajesh Kumar Daria at page 51.
Judgment starts at page 54. May I just draw your lordship's attention to contention raised at paragraph 3.
I would like to see what the constitution says.
Constitution of
15.3 only says, nothing in this article shall prevent the state from making any special provision for women and children. And 16. Four also only provides for reservation. That's it. So which rule for the Supreme Court considering in the case of
Rule, I very good, page 54. This issue arises in respect of the Rajasthan Public Service Commission. Para 3 you will have to see. The contention, because you have read the contention, clean, raised before the court, and the rule position which the courts were considering. We can't read the analysis of the law unless we read the rule. Now let me see para 3. The appellant to this appeal and the third appellant in the connected appeal were OBC candidates. The other 5 appellants in the connected appeal are general category candidates. They are not selected. According to them, women were selected in excess of their reservation, contrary to the rules. They contend that those rules provided for horizontal reservation are 20% for women category wise. TSHC by the selection had wrongly applied the principles of vertical reservation and had selected women in excess of the quota, thereby denying the selection of the appellants and other male candidates. It was contended that they had fixed the higher mark than the selected women candidate, and but for the excess selection of the women candidate, they would have been selected. The appellants in this point, I mean before. Then what is the rule which is governing it? So in the rule in the paragraph 5. Rule 9 of the Right Service Rules, which is relevant, read as follows. Reservation for women shall be 20% category wise in the direct recruitment. In the event of non-availability of eligible and suitable women candidates in a particular year, the vacancies so reserved shall be filled in accordance with the normal procedure, such that it shall not be carried forward in the particular. And the reservation treated as a horizontal reservation. That a reservation of women candidates shall be adjusted proportionally in the respective category to which the women candidate belongs. This is the rule. So this is the horizontal reservation provided in their rule 9.3. Interpretation of this rule 9.3. Grievance of the petitioners before the Supreme Court is this rule is not properly followed. Supreme Court held, yes, once you have specified it as a horizontal reservation, you are required to follow the horizontal reservation. But my rule is not the horizontal reservation as I was referring to. Therefore, this judgment which proceeds at paragraph 7 and 8 are all with reference to that issue. May I just draw your lordship's attention to paragraph 1, how the Supreme Court dealt with that. Page 58. The appellants believe that the selection process adopted by page 58 paragraph. The appellants believe that the selection process adopted by RPSC was contrary to the reservation policy contained in Rule 9.3 is justified. But the question is whether the entire selection should be set aside. That's the question now to be done. Because Rule 9.3 is justified. Here there is no rule describing horizontal reservation as incorporated in Rule 9 of the Rajasthan Judicial Service Rules. So this judgment cannot be relied upon by the petitioners. This is my respectful submission. My rule is that. Now my friend wants to read the AP rules. May I just draw your attention at case 5. Yes.
My lordship, in the respect of TSPSC, my lordship passed interim order in about half a dozen cases.
Don't interfere.
Every issue is a different one.
Madam గారు చూశారు కాబట్టి I am saying anything.
Rajesh Kuvalariya, myself, I have passed out.
Passed out.
That's not Rajesh Kuvalariya, TSPS.
TSHC.
You lordships have relied on that judgment and passed the order.
I have directed them to follow Rajesh Kuvalariya, that's
But at that time,
So once,
neither the petitioners or the respondents have not got to notice the contradiction in the rule 93 of the Rajasthan rules and the state. That's the.
We are also in the dilemma to implement or not to implement. Therefore, the matter was entrusted to GAD. Not AG is appearing into matters. Until unless it attains finality, we cannot proceed further also. That was my. Selection కూడా అయిపోయింది.
All are over. But when does the bag end up? After the selection.
After signing the writ petition, selections were made. They were given appointment subject to the result of writ petition. There is a specific rider in the appointment order. We came, second case, first case came later. This case, we, before finalization of selections, the petitioner approached the San Court.
Therefore, this rule has to be properly protected. If one take the judgment without reference to the rule position applicable in the events. Now you are to see what is the state of Andhra Pradesh has done at page 125. The date of 17/4/2018. What was the rule in position which I have referred to? Andhra Pradesh made an amendment by DOMS number 63 dated 17/4/2018, taking into consideration the judgment of the Supreme Court in Rajesh Kumar Garya and made an amendment to the rule. So this amendment should be applicable in the state of Andhra Pradesh from 17/4/2018. There is no such amendment in the state of Telangana.
there is the Telangana rule.
Telangana rules run from 136. There is no amendment. Rule 22J 2 was amended.
UMS number 107. Is it there, anybody? Substituted by UMS number 107. Dated 27/7/2018.
107 is.
Has it been filed by anybody?
2018.
18.
Yes. This is only in respect of the sports court. Page 141. At page 141, clause 3. But the government was aware. 141, may I read it? In the case
Why
of-
did they have to mention here, under provisor to 22? Rule
Sorry,
22.
the page 144.
138.
138.
Under the proviso, there is a reference to UMS number 107.
107.
And also under the
107 is the only in respect of the horizontal reservation for sports.
Not only that, added by GMS number 107. 107 is mentioned even before, under the sports quota.
Yes, sir.
So it may be reference to.
So may I just 141, in the case of appointment to the post mentioned in clause 3 of Rule 2 of Rule 48 and so in which 100 vacancies shall be hereby horizontal reservation under sports quota in direct. So they were conscious when they issued the GO 107.
I'd like to see 107.
107. And not 5. Delete. 107 is.
Maybe it is.
7
So what about the other reservations, like backward and they're all vertical, so they're not. So we have sportsmen, you are following horizontal.
But I have a copy of the.
Persons with disability. Huh?
107 I have a copy.
What does it say? What does it?
It's only for the sports.
Only for sports to done. And why is this mentioned under this women's reservations, all other reservations? Federal caste should have social and educational, women and persons with disabilities, all the excellence, nothing HIG. But here there is no reference to sports code at all.
That original, the last minute, read D, my lordship, page 138. It refers to only sports quota. Proviso
Has been added
subsequently enlarged the scope. Actually, rule relates to sportsmen only. D, your last may kindly see D. In case of appointment to post which principle of reservation of appointment applied out of 50 as the case may be, 45 appointments to be made on the basis of open competition. 2 appointments shall be reserved for direct recruitment of meritorious sportsmen. For that proviso, this rule refers to only for sportsman reservation. This proviso cannot enlarge the scope of it to women and treating it as a vertical reservation.
But in the proviso, there is a reference to all categories.
This is there, but proviso applies to D only. D originally speaks of sportsmen, sports quota. My learned friend cannot enlarge the scope of a proviso to that of main.
Yes, sir. In rule 22, sub-rule 2 for clause E, the following shall be substituted. Namely, in case of appointments to posts which are the reservation of appointments in place, 50 as it is maybe 45 appointments to be made on the basis of open competitions. 2 appointments shall be reserved for direct. Provided that the claims of members of scheduled caste, scheduled tribes, social and economic. So this proviso is applicable only to people.
To women, there should be a common law. Then that purpose would be served.
Provided that the claims of members of scheduled caste, socially and educational backward classes, women, and the persons with disabilities are excelled, as the case may be, shall also be conferred for remaining appointments which shall be filled on the basis of open competition. The number of appointments reserved for that category shall in no way be affected during the period the reservation for that category is in force.
So this proviso is applicable only to D.
D, but
only to D.
But this proviso replaces that reservation in claims of the members of the women so and so shall be considered for the remaining appointments.
So that's not in other category, only in the sports quota.
No, I am not trying to say. Then in the open competition, they will be considered. That is the proviso.
Open competition, you will be considering everybody, including men, women, BC, SC, ST, all categories, you will be considering another open category on the out of the merit.
In respect of the women reservation, we are not changing unless there is a rule.
You are saying that, it is not horizontal, it is vertical. What is the basis for you to say that you are following vertical?
The rule which
rule permits you.
The judgment of the Supreme Court referred to is the rule which says shall be horizontal reservation. In my rules, there is no rule. In my rules, my rule, what my rule would do, I'll just trust. My appointment is.
And if you see in this, the proviso is only particular to D only. You'll see the inverted commas opening at D and ending after the proviso.
Yes.
So this proviso is strictly applicable.
I tell you that Now, when I make the rule, I have to make it page 138 again. My rule shall be, I have to make the rule of reservation in the 100-point roster in this manner. Now, when I make the open competition rules, rotation number 1, it is meant only for women. But when it comes to the number 3, this candidature of this post of open competition is available to both men and women. Unless rule contemplates, I have to follow the horizontal reservation as specified in the sports quota. There is no elimination of women for the post which were earmarked on.
No, there need not be any elimination. But giving extra post.
There is no extra post.
More than 33%.
I may put it in another way.
No, in this roster now, as per the roster given by you.
Yes.
How many posts are reserved for women?
Yes. And I may again.
Yes, sir.
Because 107, I may again.
Yes, sir.
Clause G says in the case of appointment in post in which principle of reservation are applied out of 50 as the case may be. 45 posts to be made on the basis of open competition. 2 appointments shall be reserved for direct recruitment of meritorious both men and so and so. Then there is an amendment 3, not clause G, that is the appointment under the rule of this rule shall be made page 138 to not missing. E. Page 130. Appointment under this rule shall be made in the order of rotation specified below in a unit of 100 vehicles. Then you rush it over to the next page, provided that first proviso is 1, second proviso is number 2, third proviso is at page 141.
Yes.
So in case of appointment post mentioned in clause B of subsection 2 of rule 22, that is what the 107. 48 and 98 of points terms in each unit of 100 vacancies shall be earmarked to horizontal reservation under sports quota in direct recruitment. So there is no amendment to the rule D proviso, but horizontal was referred to clause 3, proviso to clause 3 under 107. So if they wanted to make women reservation also horizontal reservations, they could have made it. They are well aware what is to be made a horizontal reservation, what is not. I'm not 7 again. We read that make it. So in 107, proviso there is no horizontal reservation, but sports quota they clearly earmarked that there is a horizontal reservation. The rule making authority was conscious. What is to be treated as a horizontal reservation, what is not.
Where else is horizontal? Except here, there is no other.
No.
Vertical reservation is mentioned?
Yes, no. Once the horizontal reservation is not there, the procedure is other than the horizontal. Here,
that is a special, no. When it is a special reservation,
there is
has
no
the
speciality to the normal.
No, if it is.
Special only will be incorporated in the rule. Otherwise, it will not be. That was the reason. Otherwise, there is
100%, 100
Point
points. Have you followed the 33%?
Yes, sir. But I strictly adhere to this 100%.
So, and also then horizontally also you have.
Horizontal is only for the purpose of sports code.
So all these people who have been appointed, are they under the sports quota?
No.
So you have given vertical reservation for.
I have given the reservation
And also horizontal reservation.
as provided in the rotation of 100.4, which I adhere to. When it comes to the women candidate, I consider the woman. When it comes to the general candidate like open competition or a BC candidate,
So you have not provided for horizontal reservations for women at all.
there is no prescription of
No, but
providing.
here if you are following this proviso, what you said was, wherever reservations are there for women, we are not going to.
Wherever, what is that?
That number is not going to be disturbed.
Then I will read proviso. It says, women shall also be considered for the remaining appointments, which shall be filled on the basis of the open competition. So, in
The
respect
number
of
of appointments reserved for other category shall in no way be affected during the period.
reservation for that category is in force. What that category is in force is women. Proviso. This interpretation has not been made by Rajesh Kumar Daria. There is no reference to the Rajesh Kumar Daria in this case. Reason is Rajesh Kumar Daria rule 90 clearly contemplates horizontal reservation. To contend that there you should have followed the horizontal reservation, there should be a rule.
What is Idrasan?
My friend is going beyond the rule because this is rule which I have.
Idrasani also is with regard to reservations, and there is also a reference to women reservation, and that it should be horizontal.
Yes.
So what is that?
Paragraph that would be coming for consideration if the rule is under a challenge which has not prescribed the horizontal. What is the
Was it under the rule or was it considering the reservation policy? What is it?
paragraph 6? It's within
6 or?
Page 55.
Ah.
They explain what is meant by vertical reservation and horizontal reservation. Paragraph 6. Before examination of the student. In Indira Sahani, the principle of horizontal reservation was explained thus. All reservations are not of the same nature. There are different types of reservations which may, for the sake of be referred to as horizontal. Reservations in favor of scheduled caste, scheduled tribes, and other backward classes may be called vertical reservation, whereas reservations in favor of physically handicapped can be referred to as horizontal reservation. Horizontal reservations cut across the vertical reservations. What is called interlocking reservations? To be more precise, suppose 3% of the vacancies are reserved in favor of physically handicapped persons. This would be a reservation relatable to class 1 of Article 60. The person selected against this quota shall be placed in the appropriate category. If he belongs to SC category, he shall be placed in that quota by making necessary adjustment. Similarly, if he belongs to open competition category, he will be placed in that category by making necessary adjustment. Even after providing for these horizontal reservations, the percentage of reservations in favor of backward classes of sections remains and shall remain the same. So it is talking about what is the
There is a Anil Kumar Gupta. Next
Now,
paragraph
Anil
7.
Kumar Gupta. This is in the UP regulations. The proper and correct code is fulfilled first of the posting quota on the basis of merit, then fill up each of the social reservation quota, SC, ST. So, and so third step would be to find out how many candidates belong to special reservation have been selected on the above basis. If the quota, that is, if there is a reservation, special quota and a horizontal reservation, earmarked in that rule.
So they say social reservation should always be horizontal reservation.
Does not say.
Social reservation should be vertical reservation.
But that is the analogy, but my rule is as
The
of
Supreme
today.
Court says something.
No, Supreme Court cannot interpret
my rule unless my rule is under challenge. Otherwise, not then every Supreme Court judgment cannot be applied unless there is a contest to the rule and this rule is not in conformity with the rule, therefore set aside. That is not the plea. That is not the plea before your lordship in the restriction. Scope of my notification, whether it is liable to be set aside on the ground of Rajesh Kumar Daria judgment. That's all. My respectful submission is Rajesh Kumar Daria judgment is on the basis of a rule which has no application to the rules which I follow. Otherwise, some rule in Tamil Nadu, they may say not even vertical horizontal some other reservation. Supreme Court avoids that. That can't be made up to Telangana. Merely because Supreme Court heads up. Every judgment is not a judgment in them. We have to see how the context the judgment was delivered. Supreme Court was considering the rule 9 of the Rajasthan rule and held whether the appellants were denied the benefit of implementation of that rule. Otherwise, tomorrow some other judgment is coming. It is a clear. And my friend himself has filed this order of the Andhra Pradesh would clearly show that if that amendment was made in the state of Andhra Pradesh, the classification of the rules of 22 is vertical. In state of Telangana also, when they consciously made an amendment to the sports quota, they have not adverted to that horizontal reservation rule follow. If that conscious decision of the state of Telangana is taken into consideration, reservation for women is not a horizontal. No NRID can be taken into consideration unless the explicit rule is challenged, saying that take a bar, whether it is in violation of any constitutional provision. Then it is for the state government to take an appropriate. In the present case, there is no challenge by the rules. There is no challenge to the notification. If my friend participated and secured the selection. But the petitioner here is the main candidate. In the notification, no vacancy is available for PCA candidate.
PCA male candidate.
Therefore, he would not get the.
No, that's what he's saying. He's challenging the reservation given.
But when I issue the notification, he is aware that whether the post is available under PCA category. He does not have any post under PCA category to consider his candidature.
The last one continue. Tuesday or Wednesday.
Not immediately after this. Other than reopening day of
Next Thursday, your lot. Next Thursday, your lot. My land friend has not filed. My land friend role is limited. My land friend has not filed.
Yes, now,
But-
because that amendment is only things to be in Andhra Pradesh.
But
State of Telangana has not amended the rule.
Not amended.
You think about it. How it will help recruitment.
It's not in.
They are interpreting in a wrong way is our submission. If required, I will amend the rule itself.
Only think about it. If the court were to accept, then
Constitution.
consequences of that, what it will have on yours like. Think about it. I'm not saying that we have not decided.
I will think of it and discuss with the senior Prakash sir and file appropriate.
Saying because now you are showing that they have amended the rules and all.
Constitution.
Just point out that the rule has been amended by Andhra Pradesh and not.
That was already repealed by a division bench of this on court, Miladu.
Sir,
The same rule, similar rule, and verbatim similar rule.
I'm not saying, telling you anything.
Here also, there are,
What the consequences if the court were to accept it and what will happen? So,
uh,
think both ways. 17th.
one more aspect, Your Lordship, without any amendment, in respect of AE notification, they treat one reservation as horizontal reservation. I filed that notification also as additional material paper. There is no, if my learned friend's argument is accepted, they cannot treat women reservation as horizontal reservation.
Post in a different category.
But
that is not the challenge here. Whether the submission is post notified is in violation of any law.
All right. It shall take it as part head, we have spent some good time.
Thursday, next.
Thursday as part.
My last item. Item 82 and 83, yes. Yeah.
82 and 83, yes, sir.
If any chance, we'll have tomorrow. Urgent motions.
Can't say tomorrow, but next week definitely. Not tomorrow,
The remaining cases will come only next week.
next week. Some of them may come tomorrow. Tomorrow is Friday.
Friday.
So they may not, they'll be in the list, onward list.
Milord, at
They
least,
may not be taken up.
Milord,
I'm seeking next up.
kindly add up for next week, Milord.
Yes, sir. Shall all come next week.
Let him share that notice.
1,
77.
Fine. Sir, all matters can be posted in the adjournment, then there is no meaning of that adjourned motion list. It can become like I can have only one list. Yes? 80? 81, huh? What do you want? What do you want?
We continue to